I realized after I left our study session that I shouldn't have left, so I'm back.
Welcome back.
I think we have everyone. Let's see. So. I will call to order this regular meeting of the Los Altos City Council on Tuesday, February 22nd at 7 p.m. Would Deputy City Clerk Rodriguez please call roll and establish quorum?
Yes, members of the council, if you are here, please indicate so by saying aye. Councilmember Flygor.
Here.
Councilmember Lee Ang.
Aye.
Councilmember Weinberg.
Aye.
Councilmember, I apologize, Vice Mayor Meadows.
Here.
Mayor Enander.
Here.
Everyone is present, Mayor. You have a quorum.
Thank you very much, Deputy City Clerk. And it looks like the next thing on our agenda is our Pledge of Allegiance. And it looks like Aria Tatavarde is there and ready to go. So hi, is it Aria? Did I say that right? Great. Are you all set? Would everyone else please mute? And Aria, start whenever you're ready.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Thank you so much, Aria. And what troop are you with?
Santa Rita.
And where do you go to school?
Santa Rita Elementary.
Very good. And what grade are you in?
First.
Say that again.
First grade.
First grade. You did exceptionally well for someone in the first grade. So thank you so much for being here with us, and good luck with all of your activities.
Thank you.
Have a good evening. Let's see, we had no closed session, so there's nothing to report there. I do have a proclamation that I would like to read, and that is proclaiming this month Youth Art Month. So whereas Youth Art Month is an annual celebration supported through the Council for Art Education to emphasize the value of art education for all children and to encourage support for excellent school art programs. Whereas the Santa Clara County Board of Education, along with the City of Los Altos, is committed to supporting the arts to inspire and prepare students for success in the 21st century and allowing them to develop as productive, contributing members of a strong community. Whereas the City of Los Altos shares the vision of ensuring that students have access to high quality arts education that is culturally relevant and inclusive in all forms as part of a comprehensive education that sparks curiosity, imagination, creativity, and joy. Whereas while Youth Art Month supports many purposes, it exists primarily to direct attention to the value of art education, encourage commitment to the arts by students, community organizations, and individuals, increase community understanding and interest in art and art education through involvement in art exhibits, workshops, and other creative ventures, and increase community, business, and government support for art education. And whereas the City of Los Altos encourages commitment to the arts by students, businesses, community organizations, and individuals. Now, therefore, be it resolved that I, Anita Enander, Mayor of the City of Los Altos, and on behalf of the entire Los Altos City Council and the people of Los Altos, do hereby proclaim this month of March to be Youth Arts Month and encourage all residents of the city to join in this observance. And I want to mention that our Public Arts Commission is working on some special things to happen in March to enhance our youth arts programs in town, as I know that all of our schools are also doing special things to enjoy Youth Art Month. And I managed to say that, and that one's a little tricky. So thank you all very much. And next, we will move to any changes to the order of the agenda. Is there anything anybody would like us to move around? Seeing none.
Make you aware,
Yes.
make you aware, Mayor, I'll be pulling something off of consent.
Okay, thank you very much. Then we will move next, City Clerk to Deputy City Clerk to public comments on items not on the agenda. So if you are here to speak on some item not on the agenda, would you please raise your hand and follow the Deputy City Clerk's instructions?
Yes, as the mayor has indicated, there's a raise hand feature at the bottom of your screen. Use that to indicate your willingness to speak. Mayor, at this time, I do not see anyone with their hands raised to provide public comment on items not on the agenda.
Okay. We'll give them a couple more seconds just in case someone changes their mind at the last minute. Seeing none, we will move to the consent calendar. And I understand Councilmember Lee Eng, you want to pull which item?
Agenda item 3, the off-leash fenced-in dog park.
Okay. Then we will take that after the public hearing as our first discussion item. So it will follow item 4 and be before item 5. And otherwise, I'd take a motion for items 1 and 2 on consent. Vice Mayor?
So moved.
Councilmember Weinberg?
Second.
Thank you. Deputy City Clerk?
Yes, if you approve with the motion on the floor as stated, please indicate so by saying aye. Councilmember Flygler,
Yes.
Councilmember Lee Eng,
Aye.
Councilmember Weinberg,
Aye.
Vice Mayor Meadows,
Aye.
Mayor Enander.
Aye.
Motion passes. The consent calendar has been adopted minus item 3.
Thank you very much, Deputy City Clerk. We'll now move to a public hearing. The formal public hearing is to hear item ZTA 21-005, City of Los Altos for Los Altos Municipal Code text amendments, We are holding this public hearing to introduce, as read by title only and waive further reading, of a zoning text amendment modifying the Los Altos Density Bonus Ordinance pursuant to recent changes in state law. The item is further explained in our agenda, so I will open the public hearing at 7:08. Do we have a staff presentation?
Yes, I think Ms. Simpson has something to say, and then my associate Eric is here to help with going through the ordinance.
Go ahead, Ms.
Yep.
Simpson.
Thank you, Jolie. So as she mentioned, Eric Ramakrishnan will be presenting the item this evening, and it will be for clarifying some portions of the and to modify and update some portions of the density bonus ordinance in order to avoid confusion and different interpretations in the future. But one thing I wanted to mention that was noted in the staff report, under the Planning Commission's recommendations, it indicated that they recommended a feasibility study be done before changing the inclusionary criteria. But actually, just to correct that, the commission decided to include the feasibility study as part of the housing element, but did not require that it be a fee study that be done prior to changing the inclusionary requirements. So I just wanted to note that before.
Okay, so that just clarifies or corrects the statement in the staff report, correct?
Yes, thank you.
Mr. Ramakrishnan.
Yes, I think what I'll do, I don't have a formal PowerPoint presentation prepared, but I will pull up the ordinance and just kind of walk through the 4 parts of it and explain what we're generally what we're proposing, and then I'm happy to take questions from you. So this ordinance does 4 different things. Most of it amends the city's existing affordable housing ordinance. I want to shy away from saying amends the density bonus ordinance because there's really 2 parts to the affordable housing ordinance, and part of the purpose of this ordinance that we're bringing to you is to clarify that those are 2 parts because they sometimes get confused when talked about together. But before that, there are 2 things that this ordinance does unrelated to the affordable housing ordinance. And this is in response to some of the discussion that your council had last year at the end of the year when we were bringing issues relating to SB 9 to you. One of the first section here, one of the discussions that came up around SB 9 was that we had some language in there clarifying that if somebody wanted to appeal any of the provisions of the city's design guideline resolution relating to SB 9, that they could use the existing procedure in the municipal code for bringing appeals of administrative matters. And there was discussion by the council, can we put in the resolution that those appeals can be delegated to another body or to staff? And the answer was no, because the resolution, you had authority under the city's municipal code to propose design guidelines by resolution, not to do really anything else by resolution. And so we were sort of stuck with the existing framework for appeals in the municipal code. But we said that when we brought the affordable housing ordinance to you, we would also include language in there relating to appeals so that the council could decide if it wanted the ability to delegate appeal authority by resolution in the future. So section 1 just creates that authority. It doesn't actually delegate any appeals authority. It just makes it so that if you decide you want to delegate any of your appeals authority under chapter 1.12, you can do that by resolution rather than having to adopt it by ordinance, which is a much lengthier process. It just creates that authority in your council and nothing more. The other issue that came up around SB 9 that we weren't really able to deal with by resolution at the time, historically, when projects include conditions of approval that require certain landscaping be maintained in perpetuity, the city is able to enforce those conditions of approval as such, as conditions of approval. But as we're moving away from discretionary review of housing development projects and toward more ministerial approvals, projects may not necessarily have conditions of approval. And so there were questions by council, well, how can we ensure that landscaping that's required as part of a project is maintained in perpetuity? And we suggested we could bring back language that would address that in the municipal code. And so we proposed a section here that just clarifies, for the avoidance of doubt, that the failure to maintain landscaping that is part of an approval is a nuisance. And what that does is that if somebody is required to provide landscaping as part of a project, whether it's a ministerial approval or not, the property owner is now, it's very clear that the property owner has a long-term duty to maintain that landscaping. The failure to do so is a nuisance, which means it can be abated. And the city has all kinds of nuisance abatement powers that we regularly use to enforce our municipal code, which could include just ordinary administrative citations that can be reviewed by a hearing officer. The city has administrative and nuisance abatement authority. There's always the option for civil and criminal enforcement, although those are rarely used. In extreme cases, the city can have a receiver appointed to abate a nuisance. Things can be recorded against the property to put people on notice that there's a nuisance. So this just allows the city to, clarifies that the city has that full gamut of powers if people fail to maintain landscaping that was required as part of a project. So those two items are not related to the Affordable Housing Ordinance. We're just bringing them to you now because it's a convenient time. The rest of this pertains to the Affordable Housing Ordinance. And it really does, so the very first thing it does is creates two separate articles in the city's Affordable Housing Ordinance for the purpose of clarifying that the Inclusionary Housing Ordinance is different from the Density Bonus Ordinance. The Inclusionary Housing Ordinance is about the amount of affordable housing that projects are required to provide, whereas the Density Bonus Ordinance is about those things that we're required to confer on applications under state law if they do provide a certain amount of affordable housing, whether we require it or not. And so the other reason for wanting to divide those up into two separate articles is that the Density Bonus Ordinance currently is one section. It's a 13-page long section. It's cumbersome. It's not user-friendly in that regard. And so we've broken it up. It really is a new ordinance entirely now, but we've broken it up into separate sections to make it more user-friendly, and having two separate articles facilitated that. The Affordable Housing Ordinance, there are two primary changes. One is that some of the definitions that are used in the Affordable Housing Ordinance are currently codified in the density bonus part of the ordinance. And if you adopt the proposed ordinance, that would go away. And so those definitions need to still be in there. So the first part moves those definitions up front into the Affordable Housing Ordinance. The second major change, and this is not a change that the Planning Commission recommended to you, and so I'll spend some time talking about it, is an attempt to clarify our existing requirements around for sale projects, the inclusionary requirements for sale projects. Currently, the language says that 15% of units shall be designated as affordable, and that if there's a fraction, always rounds up, and that a majority shall be designated as moderate, and the rest shall be low or very low. That's caused some confusion in a couple of regards. The first is that technically 100% is a majority, but when this language was originally brought to your council a few years ago, it was explained to your council that the purpose of this language is to sort of prioritize moderate, but to achieve a mix of units. But on the other hand, if it's 100% is technically a majority, so it doesn't necessarily achieve a mix of units in every case. And so to say that a majority can mean 100%, in questions to your council when this was brought to you before, that issue came up and it was specifically answered that a majority can mean 100%. But it is sort of contrary to what the stated intent at the time was. And it's ambiguous language and has caused a great deal of confusion over time. The second reason that it's confusing is what happens if the developer wants to provide more low or very low income housing than less than a majority here under this language. Number one, can they do that? And number two, do they still have to provide the minimum amount of moderate, which is a majority of 15%? The answer that was given to your council when this language was first introduced was that in that case, the developer would still have to provide the minimum amount of moderate, but that the developer was free to exceed the 15% in order to provide more low or very low, particularly if the developer wanted to do that to take advantage of density bonus, a certain density bonus percentage. That was what was explained to your council, and I think that that interpretation is consistent with the actual language of the ordinance, but it certainly could be more clear, and that lack of clarity has caused some confusion in the past. One thing we've done to eliminate that confusion, or an attempt to eliminate that confusion, is to add this clarifying subdivision C to the ordinance. But then with regard to the majority issue, what is a majority? It appears, based upon the discussion that your council had previously, that the intent was a majority could mean 100%. But again, that's inconsistent with the purpose of the ordinance that was presented to your council. And the language is, in any event, ambiguous. And so what we're proposing to you is that we say that 15% shall be designated as affordable, and 7.5% of the total shall be designated as moderate. Now that's exactly half, but typically, because there's rounding up, the ordinance calls for rounding up anytime there's a fraction. Frequently, that moderate number will round up to be a majority rather than exactly half. And then the remainder of the units, in order to equal the 15%, would have to be low or very low. So this would achieve a mix of units out of every project, and it would clarify, instead of saying a majority, it would clarify an actual percent that would be moderate. The Planning Commission did not recommend this change in particular. The Planning Commission felt that this should be studied. The city should conduct a feasibility study before making any changes to the percentages in the ordinance. And there's certainly merit to that. And so, it's ultimately a policy question for your council. At the same time, even though there might be some merit in doing a feasibility study, in the meantime, the language is ambiguous. And if we don't change it, we don't get the benefit of adding clarity. If your council is not comfortable with making the changes proposed here, I would at least ask you to take a look at C and consider adopting that language. And then the final thing that this does, in fact, the bulk of the ordinance, is to essentially revamp the density bonus ordinance. And there's a couple of reasons for that. One is, like I said, to break it up into different sections, because it's currently all one section, and it's a 13-page long section, which isn't very user-friendly. Also, density bonus law has changed a couple of times since the current ordinance was drafted, and the current ordinance is no longer consistent with state law. Another reason is that the city's current density bonus ordinance basically restates state law as it was in effect at the time that it was adopted. And it's really unnecessary to have a local ordinance that restates state law. We have to follow state law regardless. All that we're required to do in our local ordinance, we're required by state law to have a local ordinance, and all that it's required to address is to explain what our local application procedures are. It doesn't need to include everything that's in the state statute. And when the state statute changes every single year, it's sort of duplicative and unnecessary to attempt to restate the state law. And so what's proposed here is to codify local procedures, to clarify how Los Altos interprets and implements the density bonus law and what our local procedures are, especially to incorporate our on-menu concessions and to describe our application requirements and our requirements around the affordable housing agreement that needs to be recorded against the property to establish the low-income units, lower moderate income units as lower or moderate income units. One thing that this does that's a little bit unique, but I think solves an important problem. One comment that we received was that to the extent that our local ordinance does include or does restate state law, staff and developers and even members of the city council like the ability to turn to our local ordinance to identify, they like the tables in the ordinance that identify the density bonus percentages and other information. The problem with including that in the ordinance proper is that this changes every single year, and then we have to update the ordinance, which takes time and costs money. And so what we're proposing is to take those pieces of state law that don't need to be in the ordinance, but that are helpful to have as a reference, and to make them an appendix to the ordinance. And what the ordinance says is that these are provided for information, and that they can be amended whenever state law changes. They can be amended administratively by staff to be consistent with state law without having to go through the process of adopting a new ordinance, just to make these appendices consistent with state law, since we have to follow state law in any event. A couple of points about the density bonus ordinance that's proposed here that I wanted to make too. One is that the current ordinance includes language that indicates that your council can always increase the density of a project beyond what's required under state law. That is in the ordinance because the ordinance, again, restates what's already in state law, but the piece of state law that is being quoted is basically taken out of context. The piece of state law that's being quoted is attempting to state that to local agencies that you can offer more generous density bonuses than required under state law, but your local ordinances can't impose less generous bonuses. When it gets taken out of that context and put into our local ordinance, it suggests that your council arbitrarily can increase the density of a project to whatever it wants to. There's no criteria or procedure mentioned for that. That's caused some confusion in the past. It's not helpful to say that. And so what we've done instead is we've included language in here that, we don't give a higher bonus than a project is entitled to under state law unless the applicant applies for a negotiated development agreement with the city. And then there's a process, so that it's not just an arbitrary determination that your council could make, but there needs to be a process, and it's a negotiated process. And it's a familiar process. There's a set procedure in state law for negotiating development agreements. The last thing I wanted to point out is that I know there's been discussion recently about the term that affordable housing agreement should have. This proposed ordinance has certain language in there about the length of these agreements. Of course, as the policymaking body for the city, if you don't like those, you're certainly free to use this as an opportunity to suggest different terms. But the language is in there at least as a starting point for our discussion today. And with that, I'm happy to take any questions.
Great. So what I'd like to do is go around and take questions. And then I'm guessing that sections 1 and 2 won't be particularly controversial. And so after we've had questions, I'd like us to consider, just maybe with a show of, a nodding of heads, whether 1 is acceptable as written and whether 2 is acceptable as written. And if so, then move on to a more in-depth discussion of sections 3 and 4 and take them separately, because the inclusionary is definitely separate now from the density bonus. So, but I think in terms of asking questions, let's get all the questions that you have from Mr. Ramakrishnan handled now before we get into discussion. Vice Mayor.
I thought I saw Councilmember Weinberg's hand up before me. No? Okay. All right. Thank you for that clear explanation, Mr. Ramakrishnan. So I want to ask just one question on the staff report. It's on page 3. So before you get to some of the text, but page 3 of the staff report on this item, and talking about the inclusionary housing ordinance and the last paragraph there. A couple times you talk about the term majority, and there's being some confusion. I mean, part of the ambiguity stems from whether this is an absolute or a bare majority. And so I think I understand what you mean by absolute and bare majorities, but can you give us the example with that 15% and
Sure.
And yeah, thank you.
Sure. So let's we typically don't get projects this size, but I'm not very good with math. So let's take a 100 unit project. In a 100 unit project, 15% of the units being affordable would mean that we would need 15 affordable units. If majority means absolute majority, then all 15 of those units could be moderate income. The developer wouldn't have to propose any low or very low income units. And it was indicated to your council late in the discussion on the current language when it was adopted that that would be fine. But it was also indicated to your council that the intent of the ordinance was to prioritize moderate while also achieving a mix of units out of projects. And if the developer can propose 15 moderate units, we're not really achieving a mix of units. And so that, absent the discussion that was had last time, could lead to the conclusion that we mean a bare majority, meaning 8 units would be moderate and 7 would be low or very low. And so those two interpretations have in the past been given to the ordinance. Again, it's clarified if you listen to the whole council discussion from when this was adopted before. But again, that interpretation that was given is inconsistent with the policy statements that were given for the ordinance. And it would be nice not to have to listen to a whole council discussion to know what an ordinance means.
Okay, so I'm glad I asked for the clarification then, because by absolute majority, you meant 100%.
Right.
And bare minimum was 51% or
Right.
bare majority 51% or so. And
Right.
I thought maybe it was actually, if you took 15, you were talking 15 or 7.5, that was absolute versus 50 and 100% was, or maybe it's the other way around. So it wasn't. By absolute, you meant
All moderate.
All moderate. Okay.
Would be acceptable, yeah.
Yeah, thank you for that clarification.
Sure.
Councilmember Weinberg?
Thank you, Madam Mayor. And Eric, thank you for that report. My question has to do with the administrative appeal process for an SB9 matter. If by resolution, the council authorizes a city manager or the city manager's designee to have the authority to hear an SB9 appeal, would that be a mandatory appeal that an applicant would have to go through prior to being able to file an action against the city?
Unless your council was specific in the resolution making it voluntary, it would be mandatory. That just sort of flows from the concept of exhaustion of administrative remedies. If the city makes a remedy available, somebody has to take advantage. And I want to be clear, the language we're proposing, even though this discussion came up in the context of SB9, the language we're proposing applies more broadly. So in other circumstances as well, you would have that ability to create lower level appeals.
Okay, great, thank you.
But Eric, we have to clarify that an SB9 denial goes to court. It wouldn't that be a ministerial approval? Yes.
Right, right, that's right. We had this discussion before. If SB9 is a ministerial process and it's the building official who makes the determination, and there's no appeal from the building official's decisions because they're ministerial, that's state law. But what we created the appeal process for was to appeal the regulations themselves.
Yeah, the applicability of some of the objective standards. So I just, I want to make sure that in
That's
another
clear.
year, people don't say, oh no, I thought it was different. So
Was that it, Councilmember? Okay, Councilmember Lee Eng.
Councilmember Fliger was before me, so you might want to take her first.
All right,
Councilmember Lee Eng, if you want to.
go ahead, Councilmember Fliger. She's deferred to you.
Thank you, Councilmember Lee Eng. Just a couple of questions, Eric, and thank you. I agree with the Vice Mayor. That was a very clear overview, so thank you. My first question has to do with the landscaping change. Because this is a change where we're going to require it to be ongoing, how will this be communicated? Is it going to be specified in the condition of approval so that future property owners will understand that this is an ongoing obligation?
Well, just to clarify, I mean, the reason this was suggested is because as we have more and more ministerially approved projects, we're going to have fewer projects that have conditions of approval adopted through the discretionary process. And so right now, if we have a project that goes through a discretionary process and there are conditions of approval, we can, and I believe we do, have conditions of approval that state that the landscaping that's required shall be maintained in perpetuity. And the failure to comply with the condition of approval already is a nuisance, and we have ways to enforce that. But as the state is mandating more and more ministerial processes, we don't necessarily then have conditions of approval, because conditions of approval are something that typically come out of a discretionary process. And so how do we then mandate that landscaping that was required as part of the design? We can say we're not going to approve the construction of this project unless the design incorporates certain things, but that's different than being able to require ongoing maintenance. And the solution is to have an ordinance that just clarifies that this is the expectation. Sorry,
I was just going to add one thing. We could also, just for clarity to the applicant, when with the approval letter that we send, we can include language in that approval letter so that it's very clear. They don't have to go read an ordinance, but that they'll know, that it is a requirement.
Yeah, that's a good idea. Instead of it being a condition of approval, it could be an advisory that our municipal code requires this. We're giving you notice of that.
I like that suggestion. Thank you, Laura. And then still on the nuisance piece. So our current process for code enforcement, it's complaint driven.
Mm-hmm.
And so I'm just confirming that that would still be the same process regarding the landscaping. It would have to be complaint driven, and neighbor is aware of the fact that there's this obligation. And so they would call it in, as opposed to city staff being proactive in seeking out these violations.
Yeah, this ordinance doesn't propose any changes to the city's current code enforcement processes. It just clarifies that if landscape was required as part of the original design, it needs to be maintained in the future too, and that the failure to do so is a nuisance. But we're not proposing any changes to our nuisance abatement processes or policies.
Thank you. And then moving over to the inclusionary ordinance on the ownership unit provision. I think I sat in on that meeting where the former council was discussing it and the intent. So I'm very happy we're clarifying, because I do think this was the intent, to have a mix. I'm curious whether or not saying 7.5% may add to the confusion if everybody, and not everybody's good with math. And we don't specify here that it, you round up, even though in other parts of the ordinance, that's how we normally apply it. And so for me, the simple thing to say is half, at least half plus one or something. So I am curious if we're saying 7.5%, we add language that makes clear that you round up so that people don't have to flip to other sections to appreciate that. And for me, it would also be simple majority, even though I understand that in the past people said, well, 100% is majority, which I disagree with. So my question to you, Eric, is there a way to further clarify this 7.5% to avoid any more confusion about what the intent is here?
Certainly, I mean, there is already language in a part of the ordinance that we're not changing that indicates that all percentages in the ordinance round up. And so that would apply to this. It's written to apply to all percentages throughout the ordinance. In other parts of the ordinance, we don't refer to that, but if we want to, for greater clarity, we can remind people, we can include language in the ordinance that reminds people that, any fractional unit under this formula rounds up as per section, whatever it is. I don't have the citation with me right now. Again, I think there's language, the language in there is technically sufficient to rely upon, but if we want to be, since the goal is clarity, we can certainly refer to that in there.
I'm one vote, but I would definitely prefer that, because this is a provision that we look at all the time and developers are going to be looking at it. And I think that further clarity would really help.
Can we hold that for the discussion?
And if I could just say, about discussion, my intent is when we get to the discussion portion, like we did with SB 9, the resolution, I plan to pull that up on the screen in Word so that we can redline it as we talk. So maybe that's something that we can bring up then again, if that works for you, council member.
Thanks, Eric. And I wanted to reconcile what I thought I heard Laura say at the beginning about what the Planning Commission was recommending as to the feasibility study versus what you were saying, Eric. Are we talking about two different feasibility studies? Because I thought I heard Laura saying the Planning Commission wasn't asking us to delay this, but instead we're now recommending that we incorporate it as part of our housing element update process. Is that separate from what I thought I heard you say, Eric, which is the Planning Commission actually was recommending that we hold off on making this change for the ownership unit section until we conduct a feasibility study?
So if somebody else who was at the Planning Commission meeting walked away with a different understanding than me, I welcome that. But my understanding was that the Planning Commission wanted to hold off on the changes to the for sale units for now until a feasibility can be studied, or a feasibility study can be conducted. That was what I took away from the discussion.
And is that your understanding too, Laura? Or are you talking about a different feasibility study at the beginning, or maybe I misheard you?
No, that's correct. That's correct. That is what we're saying. I think they discussed it within the Planning Commission, whether to require the feasibility study. And then at the end, there was a vote that include this in the housing element update, include the any changes to the inclusionary requirement in the housing element update.
Okay, thank you.
I mean, what some cities do, and I'm not necessarily recommending this because I think it adds a layer of complexity, but just so that you have all the options available to you, what some cities do is their inclusionary ordinance will just say that projects shall provide inclusionary units as per the housing element, and then they have a discussion in the housing element about what the city's inclusionary requirements are. My preference, and it's merely a preference, would be to deal with this today at this meeting, but if that's the direction the council wants to go, it is an option.
Okay, thank you. That's it for now, Mayor.
Thank you. Councilmember Liang.
Thank you. So when we talk about the feasibility study, what is the timeline that we would have to wait to get the information before making any changes? And how long will that, do you anticipate that will be?
It varies. I worked with a city once in hiring a consultant to do a feasibility study, and the whole process from start to finish took about a year, but that's because there was a lot of community input. It doesn't have to take that long, but it wouldn't be a quick process by any stretch.
And I can speak to that as well. You know, I've talked to, we would need to solicit some proposals from consultants, and I've spoken to several consulting firms, and, you know, their timeline is, you know, roughly, at least it would be like a 6-month at least period to do it. But we can, you know, start the process of selecting a consultant and get that process started, you know, sooner rather than later.
But then it's still within our purview. If we wanted to increase our percentage, we could this evening.
Yes, on the for sale side of it, that's true. There are some legal requirements to do a feasibility study to increase the rental percentage above 15%. I think it would be advisable if the council is looking at increasing it above 15% to do a feasibility study first. The reason for that is if the inclusionary percentage, oops, we have a visitor here, let me move her. My cat wanted to say hi. If the inclusionary percentage is too high, then we may not reach our RENA goals at all, because we would just discourage all housing development. If it's infeasible to do, developers just won't come to Los Altos.
Okay, so when you talk about reaching our RENA goals and ensuring that we have a mix, when we talked about the percentages, how can we, so can we change, like when you said 15%, can we ensure, like when you say 7%, then the difference of the percentages can be broken down, so that way we can be sure to say 3% or the remaining 3 and 4% to ensure that we get a very low unit and a low unit. Because if our goal is to achieve our mix, we're not going to do that if we're letting the developer make that decision themselves all the time on what to offer, with the majority of it moderate.
So let me explain what the current language does. And originally, when I was sort of playing with different ways of wording the ordinance, I had looked at having specific percentages at every income level. And let me explain why I didn't recommend that. What the language does here is that first we figure out what 15% would be. And then of the total. So let's go back to that 100 unit project since I can't do math. If it's 100 units, then 15 of the units or 15% have to be affordable. If it's 100 units, then 7.5% of the units have to be moderate. And we always round up. So that in a 100 unit project means 8 moderate. So what the language of the ordinance says is that if you had that 100 unit project, a total of 15 units would have to be affordable. Of those, 8 would have to be moderate, and the remaining, which is 7, would have to be low or very low. And so that does achieve the mix. It does mandate that there be those 7 low or very low units. The reason why the language of the ordinance doesn't specify individual percentages, though, is because we do have the language about rounding up. And so if you had a fraction at the moderate and a fraction at the low and a fraction at the very low, you could end up requiring the developer to build in that 100 unit project, it might turn out to be 18% of the units as affordable because we round up at each level, and that might produce an extra unit at each level. And it would sort of be a little bit arbitrary depending upon the math of the individual project too, why we're requiring a higher percentage for some projects and not others. So this is what I proposed because I felt that it was the clearest and cleanest way to get to what the language is trying to achieve.
Okay, do you understand what I'm trying to ask? Because like you're letting the developer take more of the decision in providing low or very low. But what we want is low and very low. So how would we achieve that unless we clearly state percentages as well, a percentage breakdown for low and very low as well?
Okay, so your question is directed at the fact that they could do low or very low. I did that just because that is what the city has currently allowed in the past. And
our last project that came before us did not have low and very low.
Sure.
It just
the current language is low or very low, and that isn't the part that's caused confusion, so I didn't propose a change to that. Certainly you are the policymakers, and so you can propose changes to what's presented to you. What's presented is there to start the discussion. So the answer to your question of why we can't do that is you can. It's just not what I propose because it's not what the current language says, because that hasn't been a problem in the past to my knowledge.
Okay, thank you for clarifying that. So we can't do that. Then the other question I have is when you talked about appeals, so when you, unless a resolution is taken, then at what point would those is it a blanket resolution that you're saying, or that all appeals coming forward, or help me understand, or is it per project, or you're stating it's a blanket appeal?
The goal of the language was essentially to let your council do what you want. And so what happened when that section is not about SB9, but I'm going to talk about SB9 because it came up in the context of SB9. We presented to you a resolution that proposed design rules for SB9 projects. The reason we proposed that by resolution and not ordinance is because the ordinance code, the municipal code, says that design rules can be adopted by resolution. So let me step back. The general rule is that if you want to create rules and regulations as a city council, you have to do that by ordinance. But if you have an ordinance that says we can create rules and regulations by resolution, then that gives you the power to create rules and regulations by resolution. And that can be desirable because resolutions are much more flexibly adopted and much more easily changed in the future. So you have an ordinance that says that you can adopt design rules by for single family homes by resolution. So rather than having to adopt an ordinance last winter when we were getting ready to implement SB 9, we were able to do a resolution. But as part of that resolution, some council members said, well, there's this appeal provision in here that cites to the code. Can we modify that appeals process to have a staff member or a commission either hear the appeal or maybe have the ability to hear an intermediary appeal rather than everything having to come to council? And the answer was no, you can't do that because your ordinance says you can adopt design rules by resolution. It doesn't say that you can modify your appeals process by resolution. And so what we said was we'd come back later and suggest an ordinance change at the appropriate time. And so what we're proposing here is that you can change your appeals process by resolution, so that if this ordinance had been in effect last year, you could have included language in that resolution about the appeals process. So this doesn't do anything until you implement it, and it doesn't. And when you implement it, it doesn't do anything except to the extent you implement it. So you can adopt different appeals processes for all kinds of things, not just SB 9. It's anything that can be appealed to the council, you can delegate that authority.
Yeah, my concern was, and help me understand, so when it says it's delegated to staff, most times when the appeal comes to the city council, people get notification of an appeal, as well as having to share their concerns. How would they get that information if it goes to staff? Is that information still public? Do people still get a chance to voice their concerns?
Yeah. So
I just want to understand the process, because my thing is I want, with the appeal process coming to council, it is very transparent. So I just need to understand, if it's delegated to staff, how transparent is it?
So two answers to that question. One is you can create the rules by resolution. So whatever you require in the resolution would be part of the process. The other thing is that there is language in the planning and zoning law that requires a certain amount of notice for planning appeals by state law, which is meant to implement the due process clause of the state and federal constitutions. And so if staff is going to hear any kind of zoning appeal, at least, those statutes would still govern, and we would have to include that as part of our process. But your council beyond that would have wide latitude to shape the process. That's the goal, is to create that latitude for you.
Correct. So as of now, unless we move forward on a resolution, all appeals are coming to council, correct?
Right. This
Okay.
doesn't change any appeals process. It just creates a process for you to do that without having to amend the ordinance.
But not all appeals go to council under 1.12. Ministerial appeals will not come to council. A building official's determination of certain building codes, fire codes, they don't go to council.
Right. And they can't under state law. This is just things that already come to council and can come to council.
Right. My thing is that the ones that already come to council, correct. Thank you.
Right.
And then what circumstances can the city ask a developer for financial analysis or pro forma? Because I was just in this planning commission meeting, and it was stated that some cities do that they have a financial analysis or pro forma come with the application to justify certain asks.
Yeah.
I'll start and Eric can finish, but because I was at the planning commission and I did state that some cities require pro formas, but I would not recommend it. And there is, it's contrary to the state density bonus law. And because we can only ask for reasonable documentation, and this has been clarified in some case law, but so I, as the city attorney, would not recommend it. And I think there are some cities that were requiring pro formas and they're no longer because of recent case law. And I just don't think we need to have anything that is questionable. And then I'll let Eric get into more of the details, but there are two recent cases about it, and it is saying that you can require reasonable documentation, but you cannot mandate other documentation.
Yeah, this is an issue where it would be nice if the legislature would give us some clarity. Sometimes these housing laws would benefit from a little bit more clarity than they provide, unfortunately. But what the density bonus law says is that we can't require studies in connection with concession and waiver requests, but we can require reasonable documentation. And it would be nice if the statute clarified what the difference between a study and reasonable documentation is. It doesn't provide that clarity. There have been some recent cases, as Jolie indicated, where courts have struck down cities' requirements for pro formas, because what a pro forma does is it requires the developer to quantify all intended revenue and all expected expenses. It's a detailed study, and it doesn't really cut to the findings that need to be made regarding concessions in particular. You would typically do a pro forma to show that the project will not be feasible without the concession, and the courts that have struck down those pro forma requirements have said that is not the standard. The standard is that the concession will have a cost savings for affordable housing, and that the project could be feasible without the concession, but the concession might still provide a cost savings. Those are two different things, and a pro forma is a lot more robust.
Oh, sorry.
A pro forma is a lot more robust than what you need to show a cost savings. So what the language, I think, means that you can't require a study, but you can require reasonable documentation, is you can require the developer to demonstrate or explain, provide a credible explanation of how the concession will provide a cost savings. And oftentimes it's just apparent. It's apparent on its face. For example, typically, not typically, but often developers will ask for a concession not to have to build balconies. Well, balconies cost money to build, so it's sort of clear that that has a cost savings. Sometimes the developers will want to add additional units. You can go up to a certain height before you have to change the construction site, and any units you add to a project will have a cost savings because you're making more profit off the extra units without having to buy more land. The cost savings is clear on its face. If the cost savings isn't clear on its face, then we can ask the developer to provide some documentation to demonstrate that there's a cost savings. But that doesn't mean a full pro forma, because that's overkill.
So my concern is.
Sorry, I just want to say one more thing. And we don't have that. They don't have the burden to show that it is economically feasible for them. They need the cost savings to make the project economically feasible. And so I know it's very technical and we're kind of mincing words back here and there, but it's not our burden. I mean, it's not their burden. It is our burden. And so when people want to deny concessions or incentives, it's difficult for the city to prove that, and we would end up in a lawsuit. And if we did not have any evidence in the record to show why it didn't result in cost savings. So I just wanted to finish up from Eric.
Okay, I guess I have some confusion, because when you say reasonable documentation, my concern is when we ask or when we seek reasonable documentation, the timeline is not to our benefit. And when we get that reasonable documentation, and so it can always, our request can always be ignored. So for example, hypothetical example, I want the rooftop garden, and yet it exceeds everything that they've asked for in height and everything. And but I need this to prove that it'll be more successful my density, and help me understand that, because then by the time we ask for the reasonable documentation, we're not able to get that. So that's why.
Yeah, so Eric, I'll start and you can finish. So the density bonus report is part of the project application. And so we have to get it in and for the application to be complete. And so and like when we started talking about SB 330 and SB 9 projects, a lot of the discretion that the council or the planning commission had as the project goes through the entitlement process, you don't get to reach back and start changing things. And that is one of that I think that's a very difficult thing for councils and planning commissions to understand at this point. These certain elements of the project are already locked in, and you can't go back and change those. And so it isn't like we'll be able to change the density bonus report, and I'll let Eric go on, but I do know that when we were doing the training on SB 9 and SB 330, we were trying to let everyone know the days of redesigning a project from the dais, those days are very, very limited because of the objective standards and also the permit application and the deemed complete of the application. So then I'll let Eric chime in some more.
Yeah, so one of the things that I'll start out, it may not be a direct answer to your question, but we can clarify. One of the things that the ordinance does is it attempts to provide a definition of reasonable documentation, since the state statute does not. And it indicates that reasonable documentation is a credible explanation of how there will be a cost savings that is deemed sufficient in the eyes of the community development director, essentially. That already is part of the application process, providing the density bonus report that explains that information comes in at the application phase. And this attempts to define more clearly what we're looking for, and it would provide something to point to if we reject a developer's application as incomplete. That said, I also, separate topic, but I think also in answer to your question, I want to clarify, because sometimes when we have rooftop gardens come in, they come in as waivers rather than concessions. And when we're talking about waivers, we're talking about a different standard. We're not talking about that cost savings. We're talking about the rule, the height limitation makes the project physically impossible to build, which is a different standard. And if the applicant's asking for a waiver, then they don't have that obligation to provide reasonable documentation of a cost savings, because there doesn't have to be one. It's about physical constraints in that case. So that's the difference between concession and waiver. One's about saving money and they're limited. One's about physical constraints and they're unlimited. And then, as Jolie indicated, once we accept the application is complete under the Permit Streamlining Act, we're really not allowed to ask for additional application materials from the applicant. And within 30 days of that, staff has to give a consistency letter to the applicant and let the applicant know any objective standards the project doesn't comply with. And if they're not mentioned in the consistency letter, they're waived. That's state law, and there's really nothing we can do about that. So by the time things get to council, sometimes they are set in stone, and that's just the way it is under state law now. And that can come up in the context of density bonus.
Right, so you're stating that if we want to request reasonable documentation, now's the time to think about all the scenarios that we want to be clear that we want reasonable document justified for asking for it. And now is the time, correct?
I can't imagine that we could think of all the scenarios here, but if there's language you want to propose for the ordinance, we could talk about that.
Okay, then the other thing is under section 2, where you have 14.02.055, when you say failure in the paragraph at the end, it says failure to do so shall constitute a nuisance. Is that too vague, or should we be more clear in what then a nuisance results into the to the developer or to the HOA or whatever, to the project?
I don't think it needs to be more clear, but again, you know, we're bringing this to you for discussion, and you are the city council, and you can propose alternate language. But the reason I don't think it needs to be more clear is already this is the rule when we have conditions of approval. The failure to comply with the condition of approval is a nuisance, and we have a panoply of powers to abate nuisance under our code and under state law. And that's what we rely upon if there's a condition of approval. This ordinance is there for situations when there isn't a condition of approval. It's sort of a de facto condition of approval, and those same enforcement mechanisms are there, and they're all clearly articulated in our code and in state law.
Ms. Houston, you wanted to add something.
Thank you. Yes. Yes, and nuisance is a term of art. It's a defined term under the law. And so a nuisance, there's private and public nuisances, but this would be a public nuisance because we've declared it so. And I can get into how the burden of proof changes and it's a nuisance per se and all that, but I'm not going to. I'm just going to say it's offensive to the, the senses. There's case law and there's definition of what constitutes a nuisance. So by calling it a nuisance, it will be very broad and we'll be able to apply it to many different situations. So the landscaping being dead, dying, the trees dying, we've already can say that is a nuisance because we have defined it that way. So this does give us a lot more authority.
Okay, and then also, I think in one of my Q&As, I asked about if we want to, it would be at this time that we would include in our inclusionary housing ordinance about making our BMRs in perpetuity. Is that correct?
Yeah, so there's a section in there that refers to 55 years. Again, as I mentioned in the opening presentation, that's a policy call for you to make.
So I think the question is,
I'm sorry, I'm not sure which one of us cut out, but I didn't hear the question.
Yeah, I think council member is frozen. Let's see if she unfreezes. Council member, you were frozen. Can you restate your question?
okay, I think it was, I know you stated in 55 years and why you stated it, but what I have discovered is that, where's my paragraph? That we still varying years in which BMRs are BMRs in Los Altos. And that's my concern is about that. And
Well,
that's the reason why I want to be clear and we need to state it in perpetuity because it's stated that the maximum restricted resale price calculation is determined by the development and can be found in the buyer's occupancy and resale restriction agreement. And not all of these BMRs in Los Altos have been 55 years. And that's why I want to be clear. So that's why it needs to be changed to perpetuity.
So again, the language that's there is for discussion.
Okay.
What's proposed is 55, but you are the council and you can make that determination. And I agree that it should be consistent, which is why we've included language in the ordinance about what the term is, and it will be consistent whatever you decide. I will comment that I would like to put in a plug for making it 99 years if rather than perpetuity, if the council wants longer rather than shorter. And the reason for that is because circumstances can change in 100 years. We don't know whether a development that we approve today will even still be standing in 100 years. And to say in perpetuity, you're tying up, you're putting a cloud on title for future generations when we don't really know what future circumstances are. And so I'd like to suggest that 99 might be more reasonable and legally defensible, but ultimately that is your call.
Okay, thank you. We can say in perpetuity, 99 years or perpetuity, whichever is longer, because that's why we have historical buildings that go on that have been modernized and people have lived there for a long time. Thank
Can you
you.
hold that for discussion, please?
Will do.
Thank you.
Thank you,
further
Mayor.
questions? Any further questions, council member?
No, I'm good. Thank you.
Councilmember Flagger, did you have something else?
I just have one clarifying question I forgot to ask Eric on the effective date of these changes. So assuming council approves it and we move forward, would these changes, and I'm really referring to the ownership unit change that's being proposed, assuming it gets approved, we go through the normal ordinance adoption process. Would it only apply to new applications that came in after the effective date? I just want to confirm.
Yeah, that's a good question, and the answer is yes. Under the Housing Accountability Act and SB 330, if the developer submits a preliminary application, then the rules in effect on the date they submit that apply. If the developer chooses not to submit a preliminary application, then the rules in effect on the date their application is deemed complete apply. So for those projects that are already in the pipeline, the existing rules would apply, not the new rules.
Now, that's a good question because we've had that come up a few times at Planning Commission or Council. So,
Councilmember Liang, did you have one more?
No, I just wanted to explain that I'll be turning off my camera because I'm breaking up, or I'm not getting all the information clearly. So I'm just letting you know why I'm turning off my camera.
Thank you. And I just have one question, and that is in the appendices and the way you structured it so that all of the tables and all that kind of thing and the basic details are become an appendix or attachment. That is not comprehensive as I read it. There are some other things in the law that we haven't captured there, and I assume that that's just because you captured the most common kinds of ones.
That was the goal. It's my feeling that our ordinance doesn't need to address what's already in state law, because again, state law changes every year lately, and we don't need to restate what's in state law to enforce it. We have to enforce state law regardless. But I received feedback from a number of people saying we like to have certain basic things in our ordinance. And so this was a way to address that and try to solve both concerns.
I'm not at all challenging why you did what you did. That's not an issue at all. But the one that stuck out to me is that I know that in the latest change to the law last year, 100% affordables can now get 3 stories and a 50% bonus. And I know that one's, I didn't find that one anywhere in the tables. But there are also a lot of nuanced things about student stuff and so on that I know are in the law that aren't in there, and that's fine. I just wanted to verify that my understanding was everything isn't there, just the most common things that you expect to come up.
That's right. So the answer is yes.
Yep, that's it. So unless there are further questions, we'll go to public comment. So Deputy City Clerk, would you ask our participants if anyone wants to make any comments?
Yes, those listening in to our public hearing, if you'd like to speak or address this council, please use the raise hand feature. Mayor, I see 2 individuals with their hand raised at this time.
Let's give a few more seconds for people who may be new to the process to find their raise hand capability. Okay, I only see 2, so we will take only those 2, and we will give you 3 minutes.
We'll do our first public speaker, Roberta. Roberta, are you there?
Hi.
We can hear you. Go ahead.
Yes, I'm here. Hello?
Yeah, we can hear you. Go ahead.
Okay, good. Hi. So I do need to say that I am sort of very confused because I know we have several projects downtown, the example of the rooftop garden, where the developers are asking for waivers for the elevator shaft, but claiming that they need to have rooftop gardens to make it economically feasible, or show cost savings. And I don't understand how a rooftop garden can provide cost savings, or if they have to provide any reasonable documentation. So I think that the community is very, very confused about what authority and discretion council has and what they don't have. So if the attorneys could address that, I would really appreciate it. Thank you.
Thank you, Roberta.
Well, I don't want to opine on any projects that are in the pipeline. And I believe that some of these elevator height requests are their waivers, they're not concessions. And I think there's a lot of confusion with the public about a concession and a waiver. And I'll let the council know that we're putting together a actual memo about this actual type of issue, because the other thing people need to know, council, planning commission, and the public, is a developer can come in with concessions and then turn them into waivers, and the waivers will be granted, and there's an unlimited amount of waivers if they can show that it's necessary for the actual construction of the affordable project. And then and waivers can also become concessions. So I don't know if Eric has anything else we can talk about. I just have a concern that, you know, we do have some projects coming through, and I don't want to be opining on a project that will be coming to you and violate the applicant's due process.
Can we defer any further discussion about that issue until we have the council discussion?
Yeah.
With the caution so noted that we don't want to be discussing things that are relevant to open applications.
Yes, you've got it. Thank you.
Yes. Good.
Am I okay to, okay, I am going to proceed to the next member with public comment. Janine Valadez, can you give us a sound check?
Sound check.
Loud and clear.
Excellent. Thank you. Good evening, council and Attorney Houston, Mr. Ramakrishnan. I'm a park commissioner, but I'm speaking as a member of the public. My comments will be brief. It's basically this. I think Mr. Ramakrishnan and whoever else has helped him with this under Attorney Houston's leadership have done an extraordinary job with this edit that they're doing and this clarification. I read through it. For something that's quite confusing and unclear, they clarified in a great way. I also believe that making these things clearer for the developers will not only make Los Altos look like a better city, but it'll help them come up with projects that meet our needs and meet our expectations more easily. Not that it's perfect, but I think it's an amazing document. Secondly, insofar as deciding or putting to the test what a developer thinks they need for cost savings or for feasibility of a given project, you know, we kind of have to trust at some point. I mean, this issue of rooftop gardens, I know it's a thorn in a lot of people's sides, which I don't understand, but to me, it makes quite a bit of sense. If a developer can make a building or a development more attractive for its community, it probably can charge more money. And that provides effective cost savings. It's really as simple as that. And our roofs, they can look pretty. And I just don't understand why everybody well, not everybody, a few people are up in arms about it. I just hope that the council will have the vision to understand that the greener our roofs are, the better it is for our community and for our environment. But again, thank you to Mr. Ramakrishnan and everybody else that helped in writing this document. Thank you.
Thank you, Ms. Valadez. And with that, I will close public comment and bring it back to council. And with your concurrence, I'd like to again go section by section, starting with section 1. I think if Mr. Ramakrishnan will do what he proposed, which is to put the language up on the screen. And I'm going to try. This always is challenging because then it means I can't see everybody's face on one screen at a time. But with respect to the appeals, creating, basically enabling legislation to set an appeals process, to delegate an appeals process. And I'm going to go through and look and try and find everybody. Councilmember Lee Eng, can you put your camera back on? Great. And I'm looking across. Ken, by either nod of heads or thumbs up, are people comfortable with what's here? If so, thumbs up. Otherwise, I'll ask for comments for things you want changed. So I've got 3 thumbs up and I've got questions from, okay, no, I think we have everybody. So I gather we have no changes. We're all comfortable with this and we can move to section 2. All right. Landscaping. Anyone who wants to make a comment or potential change, please raise your hand. And if I don't see any, then we'll take this the way it is and move on. Okay, I think that was Councilmember Flieger.
Thanks, Mayor. I have no changes to the language, and I just want to confirm with Laura that the direction is clear on how we're going to handle this with the advisory versus trying to make any language or give any direction. We don't need, I just want to confirm with Laura, she doesn't need any direction from us because I really liked her suggestion.
Yes, that's fine. We can work on making sure that it's clear to the applicants.
Yeah, and the letter of approval would be a good place to put.
Yeah, I think that's a great idea.
Yeah.
All right, then we will move to section 3, the inclusionary. And let's see again. If you want to make any changes on the inclusionary, please raise your hand. And I'm having to scroll back and forth, so just give me a moment, raise your hand, give me a chance to scan everybody, because I think I see the Vice Mayor and Councilmember Lee Eng. So let me start with the Vice Mayor and Councilmember Weinberg. So I've got 3. So the Vice Mayor, then Councilmember Lee Eng, and then Councilmember Weinberg.
Okay, so I'm, the part I was going to comment on isn't showing on the screen. It's the language about majority. Wait, this looks like, this is definition. So I thought we were on.
Yeah, but it's all section 3. So maybe Mr. Christian can, Ramakrishnan can scroll down to where the,
yeah, my comment will be on the language around majority or
right, the inclusionary,
the inclusionary criteria.
Percentage. I think we've got it.
Do we have it? Okay, good.
Yes.
And I'll get it on my screen too, because I have some highlights. So my suggestion here, so I'm hearing 2 things. One is Planning Commission says before we start monkeying with some of these numbers or tinkering or whatever words you want to use, it would behoove us to do a feasibility study, and we could do that in the context of the housing element. And I think that's fair. But I also hear our Deputy City Attorney, Mr. Ramakrishnan, saying we don't have clarity, and we know this from our last meeting that there is ambiguity, and it's probably still not resolved from what we heard at the last meeting. So I was going to suggest just what could be a fairly simple clarification for now. And maybe it's not, because maybe I'm a little confused, but I hope not. And then we can get some feasibility information and build in some of the things like Councilmember Liang was talking about, trying to get more. But really, isn't, if we just say that a minimum of half the units of the base density have to be moderate, and then keep in that language where you say in C, nothing in the suggestion is intended to prohibit. So if we say a minimum of 50% or a minimum of half of the 15% or 7, however you want to describe this, if you say a minimum of half of what we require should be moderate, then that gives them the room to go up to 100% moderate or not. And you've added section C, which sentence C or whatever it is, which I think is a good addition as well. So, but I don't think we should get into trying to prescribe various different levels tonight. We don't have the information to do that. But this might, if there's a way to build that in, that might help with the ambiguity issue, which I do think we should correct tonight
so
if we can.
Before we make any actual change, can I go to Mr. Weinberg and say, excuse me, Councilmember Liang, I said you were next. Did you have anything on this particular clause?
So mine was under the 14.28.020 applicability, A1. That was.
Okay, I'll come back to you then on
change.
that. So do either Councilmember Weinberg or Councilmember Flagger want to make some suggestions with respect to this ownership units inclusionary? And Councilmember Weinberg's head is going up and down, so I'll go to you first.
Thank you, Madam Mayor. I agree with what the Vice Mayor said in terms of going forward with the feasibility study as part of the housing element or program the housing element. But I don't concur that the language should say at least the majority. I think that the language should be more than 50%. The difficult, as I recall, the difficulty that we had with the project that came up at our last meeting was whether a majority was 50% or more than 50%. And it's my recollection that the city attorney was saying a majority was more than 50%. So at least 4 of the units would have to be at the moderate level. Whereas the applicant interpreted it as, well, a majority is 50%. I think that the city attorney at that meeting was right. So I'd be more comfortable by saying more than 50% as opposed to saying 50%. One other very small point is that items A and B underneath B should be changed to numbers. So it should be changed to numbers. So it should be B1 and B2.
I know, yeah, that's on my edits right now too, so, yeah.
Councilmember Flagger?
Thank you, Mayor. And I agree with regards to the feasibility study as well. And I think I'm more aligned with Councilmember Weinberg on how we frame this language. And I said it during the question portion, which I really think I think the intent is half plus 1. And then everything else could be low and or very low. And so to use Eric's example of 100 units and 15 being the number of units we want to put in this affordable bucket, then it would be half plus 1 to get the moderate. And then the remaining number would be divvied up between low and very low. And I think based on the current language, without any radical policy change tonight, the developer could propose what that difference looks like when it comes to low or very low. We don't currently have a specific percent tied to the low and or very low. But I do think the intent when this was drafted was to have half plus 1. It was majority in the sense of a simple majority of the total.
So let me
total number of units.
Question, since half would be in Mr. Ramakrishnan's example, half would be 7.5. Does that mean it becomes 8 or it becomes 9? Since you always round up when doing calculations.
So if you're asking my preference, that's why I think even the 7.5 can be confusing. And so if
right, but what I'm saying is half of, if your target is an odd number, then half is going to be a partial.
Yes.
And that you're going to introduce another ambiguity. So that's what I'm trying to clarify.
No, I agree. But I also think there is ambiguity in saying 7.5%. But if the council is open to the suggestion I made earlier, which is even though I know in other sections of the ordinance, we make clear that we normally round up, if we add clarifying language here, taking the suggestion from Eric that it's 7.5% and just make clear that we would round up, then I think that would satisfy this ambiguity as opposed to trying to reword it with what Councilmember Weinberg and I are trying to come up with.
Okay.
Mayor, if I may, I'd like to
Yes.
clarify one thing. So I think from a policy perspective, I think I've heard, in terms of how we sort of wordsmith it, that's a different issue, but I've kind of heard two different policies presented in this discussion. One is to keep the language that's proposed here would require a simple majority as moderate, and would require there to be a mix of units in every project. And that's what I heard from Councilmember Flagor. But from the other two council members, I heard a goal of keeping kind of the current interpretation based upon the previous council's discussion, which would allow 100% to be moderate. And so I think
No.
there's two different policy discussions here. I want to clarify.
I didn't hear that from anybody. So maybe Councilmember Meadows, were you saying you were comfortable going to 100% moderate?
Yes, because I think we don't understand. I remember from Planning Commission, the issues with making very low, in particular, for sale units. And so by requiring that without the feasibility study, we don't know what we're introducing. It's the unintended consequence that the Planning Commission was concerned with. So I wanted to leave it ambiguous in terms of not defining that second half or 49% until we get the feasibility study. I think that is what Planning Commission was saying. And even if it wasn't what they were saying, I don't think that we should be defining that without information to guide us here, because I know there's great concern about very low units in particular in for sale projects.
Yeah, well, interestingly, I'll just comment that back when this language was first being debated at the legislative level in Sacramento, the original version of this language said that all ownership units that were affordable would be at the moderate level. That was the original language and the original intent, and it was only at the last minute that they changed the language to remove the requirement that any affordable owned units be something other than moderate. They allowed it to be else other than that, because the original was the premise that it's very difficult to do an ownership unit that is below the moderate level. Councilmember Flagger, did you want to say something further?
I did, just listening to this discussion, and I guess we'll have to vote on it. I still have, even without the feasibility study, and I support doing the feasibility study, because my concern is if we move forward with the interpretation and clarifying it to mean all the 15% total number of units could be moderate, that we may not get the low or very low income units that we would like to see even at the for sale level. And that is my concern here, where there's no longer this requirement to get some low, very low for sale units, because I can see developers moving in the direction, unless they do it for other incentive reasons, but doing 100% moderate. And so that's my concern. And so my preference would be to keep the language that allows for a required mix, as opposed to drafting it so that the developer can in fact opt to do all units at the moderate level.
Okay, Councilmember Lee Eng, can you clarify what your preference is on a policy level on this issue?
Well, I earlier said that it's important that we make sure we have a goal to achieve a mix of units. So I would even take the word "or" out and put "and" to have designated as affordable at the low and very low income level.
Okay.
I think, as I understand it, we're trying to help more people to have affordable housing in Los Altos.
Right.
Santa Clara County.
I just wanted to be sure I knew what your position was. Councilmember Weinberg?
Thank you, Mayor.
Rosen?
I'm really concerned that we might depress our ability to add housing. I'm worried about the unintended consequences that the Planning Commission was worried about. For the time being, I think Councilmember Flygor makes a compelling argument. So with the understanding that we're going to go forward with a feasibility study, I'll put my flag in her camp.
Okay, and I'm going to add, Eric, for purposes of formulating what a majority is going to look like, I will concur that we should not change what our current policy has been, just clean up the language, which is basically what Councilmember Flagger is saying. So we clean up that it's half, or, you know, if it rounds up, then to make it, if it's an odd number, because it's got to round up, half of an odd number has to be an even number. And if you want to wordsmith that further or not, based on the conversation, I think that's fine. But with the clarification that you were talking about, I think we can then, you know, we'll have one more chance to look at this. So I now want to go back to other comments in this section or questions in this section. And I think Councilmember Lee Eng, you had some other issues in this section.
Yes, I would like to change the or to and on the
No,
last
not
sentence.
in this section. I'm sorry, elsewhere, not on this paragraph.
It is in this paragraph I'm working on, where it says shall be designated as affordable. Yeah, he's got it.
Right, but you said there was, you earlier, you began by saying you had comments and you rattled off a section number that was different from this paragraph that we're looking at now.
Correct, but I also would like to make a correction to the paragraph that we're working on.
So, and I'm sorry for jumping in, but I just want to make sure that I get this correct. The suggestion I heard was to change this to and. You know, before I do that, I suppose the mayor will probably want to get.
I don't think we have a majority to change that.
Okay.
So we would not change that at this time.
Okay.
Okay. Then my other section was 4.28.020.
Yeah, applicability, I think you said, yeah.
Correct. So number 1, because I wanted to make sure that shall be done, would have to, I would like to see a clear percentage, so not that someone can choose all moderate. I think that sentence would have to be cleaned up. Do you understand?
I'm not sure that I do.
Because how it's worded, it allows the person to choose all 15% at the moderate level. And we just made clear we didn't want that.
We made sure, we made that clear for larger projects that had 10 or more units.
Okay,
This is where you apply only to 5 to 9 units.
okay.
And there are certain practicalities when you've got a small project. I'm not sure that trying to designate those is practical.
Okay, then then I, just to go back to the other change that we made and my argument for putting the and instead of or, because I think I was cut off earlier, is that I want to make a point that Santa Clara County statistics show that 39% of the population lives at or below the low income range. If we're trying to have a diverse mix in our community, in our housing, to achieve our what we want in our RENA numbers at the low and very low level, we're not achieving it unless we put and there. If we were to be in line with the population of Santa Clara County, we should offer more affordable units at the low and very low level.
Eric, go ahead.
Yeah. So before, when I cut in, it became moot, so I kept the comment to myself. But if we change it to and, then I think there need to be other changes, or else we're just adding more unclarity to the ordinance. If we're going to say and, then we need to clarify what amount of low, what amount of very low, and then we need to make additional changes around that.
And we do not have concurrence among other members of our council to make that change. So noted, Councilmember Lee Eng, but there is not support to make that further change at this time.
Okay.
Before we move on, can I ask, Mayor, if the language I have is what the concurrence was, or if there are further changes?
More than 50% of the total units shall be designated as affordable at the moderate level. I would, just to be grammatical, after the phrase moderate income level, you would put a comma.
Very good.
Eric, does it help or hinder to put where the or is and or, which basically gives all the options, I think would give all the options to the developer?
You mean here and
Yes.
or? Okay. I am fine with that if the council is.
Does that fly with other people? Because otherwise one could read that all the remaining units, they would be choosing whether all of the other units would be low or all of the other units would be very low. And I don't think that's our intent. I think our intent is to allow the applicant to decide what to do with the other slightly less than 50% units. Councilmember Flagger, can you weigh in?
I'll start with the and or. Matter of fact, whenever I refer to this section, I always say and or because I do think that's the intent. It could be both, or it could be either or. I still don't think the more than 50% gets us there, Eric, because more than 50% could be 99%. And I think what we're really trying to do is a simple majority. I liked your language, 7.5%. I think all we need to do is add your language referring to the roundup so they know you round up to the next number. I think that gets to it where we're saying that number needs to be moderate, then everything else is low and or very low.
And I apologize for my confusion. Can I just clarify, was that the consensus of the council that we wanted
Yes.
it to be a bare majority? It was. Okay, then I apologize for my confusion.
Nope, that's okay.
Let's see. I think I want to say reject. Okay. So the suggestion was to keep that, and I'm going to make a note for myself because I don't have the section number offhand. But can we say something like for greater clarity, all fractions?
No, I don't think all fractions. This the initial computation. The 7.5% of total units shall be designated. I think you need to put it up there. And
But
then
this
make a total set, and then make a separate sentence that the remaining units shall be designated as.
That's correct.
Okay.
So
I
go
apologize.
back to where it says moderate income level in the next to the last line.
Here.
Right there. And that's where you want to insert that rounded up. That any fraction should be rounded up.
Clarity.
Yeah, I think because this, 65915 goes on for pages. I think it's 65, it's Q. Each component of any density calculation, including base density, bonus density, resulting in fractional units, shall be separately rounded up to the next whole number.
Yeah, the problem is if you read that exactly, then it would mean that both of these calculations potentially would get rounded up, and we don't want to go there. Because you're doing your initial calculation and then you're saying 7.5% has to be a moderate. And if that's a fraction, you round that up, and then the rest is netted out against the 15. Councilmember Weinberg? You have a suggestion here?
My concern is that we're now changing our policy. If 7.5% comes out to a whole number, then we're not saying a majority, we're saying 1/2 or more. So applying this to the last project that we were considering, 3 moderate units would have satisfied the statute. Whereas our policy was no, a majority, 4 is needed to satisfy the statute.
Yeah, trying to say that gets tricky because if we say 50% plus 1, well, the 50% might already have rounded up. So then we're adding the,
We're just saying 7.5%. And I do think we need to insert the word with before the 7.5%. And Councilmember Weinberg, can you talk through those numbers again? Because I thought with the 7.5 rounded up, that's how we would end up with the right.
it usually does, but in some cases it won't.
In projects where 7.5 does not come to a whole number, then yes, we are rounding up and we will have a majority at moderate. But where 7.5 is a whole number, then 1/2 of all the BMR units will be moderate and 1/2 will be low or very low. Whereas the policy that this council had adopted prior to today is that a majority of units had to be moderate. So if 7.5 was a whole number, the developer would be obligated to go 1 above what would be 7.5.
So the intent here is really to say only when 7.5% results in a half unit do you round up. If it results in a whole number of units, there's no rounding up necessary.
That can
That's
occur.
what I'm hearing.
So, exactly. Eric, I'll leave it to your legal magic to draft it as such.
Yeah.
Okay, so I'm going to make a note.
Do you know how many conversations we've had about this?
Council.
And with staff, and everybody can read it so differently, and that's why we're trying to clarify it. So it's a struggle.
Well, hopefully we end up with clarity as a result of a group think instead of a camel.
If there are changes that we're going to go back to the drawing board on, and maybe Jolie should weigh in, is the council okay with the fact that we might have to come back for another meeting to introduce the ordinance plus the second reading?
No, this is just introduction, so we can make all our changes.
Because this is not a significant change. This is just clarification.
Yeah, well, but also we just don't want to, when this comes back and goes on consent, we don't want to make any more changes when it's on consent, because then we'll have to have another hearing on it. So speak now or forever hold your peace.
Right. Everybody okay?
I suppose we could say, I'm thinking out loud here, which is always dangerous. I suppose we could use the more than 50% language and then add another one of my 4 greater clarity clauses, that the intent of this ordinance is to...
if we can get through the other issues here, then we're going to take a break, because we always take a break a little at about 9 o'clock. And during that break, you can have a brainstorm.
Okay, very good.
How's that?
Very good.
So is there anything else in section, in this section that has to do with all the inclusionary stuff that anyone has any comments on? Going once, going twice. Okay. Then moving to the actual density bonus.
My hand was raised.
I'm sorry, I looked and it wasn't. I'm sorry, council member. Go ahead.
So I think under inclusionary, this is where we put that we want in perpetuity somewhere here, and it's not in here.
Where is the
So
term?
then we would add it.
That is dealt with in the density bonus.
It's not in
That's what
here.
I thought. That's in the density bonus section, not in the.
Okay, sorry.
It's in Article 2.
Okay, so sorry, so
I'm
sorry.
sorry. It's in
thought it would be here
Article.
too. Okay, I thought it would be here too as well. Okay.
No.
Okay,
We're trying to put things only in one place for where they're
Okay,
most
sorry.
relevant. So
we'll hit it there.
Eric, can you go ahead and scroll down to the next,
Sure.
to where the density bonus stuff is?
Okay, let's try this. Oops.
There we go. So why don't we just go gradually through here? Definitions. Anybody have anything in the definitions?
Shall I advance or shall we keep
Keep
it there?
going. Yep.
Okay.
Okay, this is where there tends to be questions. This is just definitions, so I think we can keep going because this is definitions that are right out of the statute.
This one is not a definition that's out of the statute. If you'd like an explanation, the statute just uses the language identifiable and actual cost reduction to provide for affordable housing costs. It doesn't define that. And so the interpretation that I think, I believe most land use attorneys give that is cost reduction to provide for affordable housing costs doesn't mean any cost reduction. It's a cost reduction that is consistent with the amount of subsidy that the developer needs to, that the developer is providing to provide the affordable units.
Right.
And this is the normal way that that subsidy gap is measured.
Right.
So I'm trying to provide clarity that the statute doesn't provide to be consistent with how I believe it should be interpreted. And I want to clarify too, on that note, that this maximum allowable residential density is, the statute uses the term gross density. And so HCD has sent technical advice letters to cities threatening to decertify their housing elements because they apply net density. And so this is meant to provide direction for staff so we can avoid that issue. And then here is what we talked about, trying to put some flesh on the statute's term reasonable documentation to establish eligibility.
For a concession.
For a concession, right?
So do we, here's a question that I have. Do we have in our procedure a request for reasonable documentation regarding waivers?
The standard for the waiver is that applying the rule that the applicant is trying to get waived would physically preclude the project.
At the density, that people tend to forget the at the density part.
At the density, right, at the density proposed. And well, let me remind myself here. I think there is something in the application procedures. If you don't mind, I'm gonna scroll.
Not at all. Because I think that's one of the concerns I heard from Councilmember Lee Eng, and it's mine also, is that if we need to have the appropriate request for whatever documentation we can ask for with respect to concessions and with respect to waivers.
Right. An identification of any waiver or waivers sought and a detailed explanation of why the development standard from which the waiver is sought would have the effect of physically precluding the construction of the development at the density and with the concessions or parking ratio reduction sought. And then it goes on from there. So you can take a look and let me know if you have any comment on it. This second sentence, this is the way we have been implementing the waiver request in those districts that don't have a standard density. This is
Right.
a common way to deal with that problem, because otherwise, since we don't have a density requirement in those districts, we couldn't deny any waivers unless we required a base project to be shown.
Right. Councilmember Lee Eng?
Clarifying, earlier, Council Houston, something about some waivers change into concessions and concessions change to waivers. So at what point then, that's why in requesting these reasonable documentation, when they have conversions into either or, how can we ensure that the documentation?
Right, because what I'm seeing here is an identification of what's sought. The justification shall include an analysis demonstrating the maximum number of units that could be provided without the waiver, blah, blah. So I guess the question is if, and I understand what Ms. Houston said, and I understand what Ms. Simpson said, that sometimes as a project is going internally in the staff, things that initially looked at as concessions, they change, the developer will change and ask as a waiver or vice versa. The question is, once that is, quote, fixed and the project is there, the application is deemed complete, then at that point, staff should be certain that whatever is now being asked for as a waiver, we have the information that supports that waiver under these criteria that are here. And the same with the concessions. And do we have a way of making sure that if the developer has done that kind of switch in the process, that we're getting the appropriate change in the nature of the information required? And that's really a question for Ms. Simpson, I think.
Oops, sorry, taking me a
All
second.
right, no, go ahead.
So do we have will we have the appropriate documentation for the justification after if it changes? Is that what you're saying? If it changes?
Right. So if they come in originally asking for something as a concession,
Mm-hmm.
and then during the loops that you often go through, that changes to a waiver, do we then ask them for the different information that's needed to justify a waiver than what they provided for when they were asking for it as a concession?
Yes, we can. We can ask for it at that time, and we would, because just if there's a difference, we would require it.
Because that's something I've not seen. What I've seen is an original density bonus, a justification from the developer, and then even when it gets changed, that document has never changed. So that's why I'm asking the question.
Okay.
And I just want to clarify that the language here, the intent of this was to address what I think the point that's being raised is, if the applicant wants to change the project they propose by requesting a waiver as a concession or vice versa, that's an amendment. And that needs to be done through an amended application. And that was the intent of specifically calling out application or amended application.
Great. Because it seems like it gets changed before it becomes a completed application, before it's determined by staff to become a completed application. And that's where we're not always getting the information.
Well, if they make the change before the application is complete, then that's fine in the sense that their application is whatever it is by the time it's complete. But if they want to come in after they have a complete application and make a change, they have to do an application amendment.
Understood. Councilmember Lee Eng?
I missed what Ms. Simpson had to say because it cut out and it froze. So I missed everything she stated.
Sorry. Did you
want to say that again, please?
I was saying that we can ask for, if they're going to change from a concession to a waiver, we'll ask for the appropriate documentation that would correspond to what their request is. And if it's before the application is completed, then it's fine. It's part of that original application. But if it's after it's been deemed complete, they can come back and amend the application, but to provide the proper documents.
So my concern is now, Mayor, is that this is a ministerial understanding. And that's why I feel that our language is not clear in providing that or requesting that. And to me, it needs to be documented clearly so that it's understood by everyone. So if we have staff turnover or something, we're all clear on this. Do you
And
Okay,
so if
so
you have suggested language,
are you comfortable with the language here and only concerned about the application with staff turnover, or are you uncomfortable with the language?
I'm uncomfortable with the language being clear because that's why it wasn't clear to me. And that's why I'm asking all these questions
Okay, so
and raising these concerns.
do you have specific suggested changes to any of the language here?
Well, then I would turn to Mr. Ramakrishnan to use his magic again to make the language stronger to achieve what we want.
I guess I thought the language was sufficient. So if it's not, it would be helpful if you could explain to me what you're looking for to say.
Because you were saying how when they submit an amended application, and I don't think that everyone's clear on when it's an amended application, or when these changes occur and the switcheroo occurs. I mean, I'm not even clear about these amended applications now. You're telling me that they're supposed to submit, but I don't believe, or I'm not clear that they are being properly amended.
I suppose we could add a B that indicates that if the applicants, and I'm thinking out loud here, so forgive me if this doesn't come out right the first time. If the applicant's proposal for concessions and waivers changes after the application is complete, the applicant shall submit an amended density bonus report that includes all the information required under subdivision A above. Is that?
No, I don't think that'll fix it, because sometimes it changes during the processing loops before it's deemed complete. But what happens is that the first submission, they come in with a density bonus report and they come in with a set of concessions and waivers. And if they change those during the staff review process,
well,
they don't change the density bonus report.
Okay. Yeah, I mean, if the staff should not be reviewing the project until the application is deemed complete. The idea under the Permit Streamlining Act is that the way I describe it, because I used to be a teacher, is at the application stage, we're just checking that the kids did their homework. We're not grading it yet. And then once we have it, then we can grade it. But we can't grade it until we've collected it all, right? And that causes confusion, but that is the way it's supposed to be. So the applicant should be able to amend their application as much as they want to until the application is deemed complete, because it's at that point that it's deemed complete that now we're going to start to review it and do the consistency analysis.
Okay, and that would mean, and I realize that there's a lot of change going on within the staff as to how they do things because of SB 330, and I recognize that. So my question to Ms. Simpson is this adequate to solve the issues that Councilmember Liang and I are raising, which is that by the time you get to a completed application, you have a density bonus report that matches what's actually going to be reviewed and what's being asked for?
I would say yes, because we won't consider it complete unless it's reflect, if they change it prior, while they're submitting and prior to completion, they, it's not going to be deemed complete unless, they've provided all documentation for waivers and concessions. So I think this gets at it, because after it's deemed complete, again, what we're saying is then they would have to submit this amended report.
Unless it's addressed in the definitions and we have clear definition of what an amended application is and what a complete application is.
Well, there's legal definitions already as to what constitutes a completed application.
Right. I mean, if they're making changes before the application is complete, it's not an application amendment. It's
right.
But once the application is complete, if they want to make changes, then they need to submit an application amendment at that point.
Yeah, because in the past, those were called being refiled. They would say they refiled, they refiled, they refiled.
Mm-hmm.
And that's where I would see the changes here, but not a change in the density bonus. So
is there?
So I'm okay with this.
Okay.
If we have the in-house process to make sure, and again, this goes back to application, to make sure that when something is deemed complete, the requested waivers and concessions match up with what's in the density bonus document that they've submitted.
Well, that is the document that articulates what their request is. So
yeah. Supposed to.
Yeah.
Okay. And I'm sorry, I've been ignoring some of my colleagues. Does anyone else have anything they want to say about this? Nope, beating a dead horse. Oh, Councilmember Flagger, go ahead.
Really didn't want to. I just want to make sure, and I don't know the answer, so I really want Laura and Eric to confirm this. Is it any changes to concessions and waivers that would trigger this? Because the way it's currently drafted, it says if the applicant's proposal for concessions or waivers changes, then XYZ. I want to make sure that is accurate. If it's because it doesn't specify what kinds of changes.
Are you proposing alternative language to what's here?
No, I'm not. I just want both of you to confirm you're comfortable with the way it's drafted to say any changes would trigger this.
I am comfortable with what I put here. Laura, do you have any comments or concerns?
No, I think we can be sure that it's, explained to staff in a procedure, procedurally, it can be explained in a way that can be, codified, administratively. Yes.
So I just want to make sure that because the prior section mentions an amended application, but this says requiring an amended report. So,
okay.
So, but I think what we do is we allow them to submit an amended density bonus report after they've been deemed complete. We don't make them go through a new application process.
Right.
So are we good with that? Because an amended density bonus report is different than an amended application.
Yes, with an amended application that requires like a new review, it triggers a new review and it triggers a new fee, which is costly. So I would say this language in B reflects what we would typically do, what we would do,
I think that's what we do, but unless the applicant comes in and changes all their for sale units to rental, then we make them go through that's a whole new reapplication.
Julie, are you suggesting deleting the highlighted language here to be consistent?
That's different.
Yeah, because I just, I'm trying to make these two consistent, and they're not consistent right now. One's an amended application and one's an amended report. I think we might, I think if we strike or amended application, we'd be consistent, but I want to make sure that's what people want. I don't think we make them file a whole new application if we change waivers, concessions to waivers or waivers to concessions.
No, right.
So I think we should probably strike that language now that we're beating this dead horse.
And do any of the council members have feedback on that?
No, I understand what she's saying.
I mean, we're trying to get rid of some ambiguity in one section, and now we're, yeah, I think that would be, now that I'm looking at it in this, now that we've changed B or whatever,
because you're not going to codify everything that might have to get resubmitted with an amended application, because all kinds of things could end up getting changed with an amended application.
Sure.
Yes.
Good. And one of our council attorneys, our council member attorneys is nodding her head. That's always reassuring.
Mayor, I thought I saw a hand. I don't know if you want to.
I'm looking. Yeah, Mr. Councilmember Weinberg, I think I see your hand.
Yeah, I think I'm losing the forest for the trees. Well, what is the problem that we're trying to solve here?
What we're trying to solve is that if during the course of a review of an application and leading up to what is likely to be a ministerial approval, the developer changes what they've asked for in terms of a concession and they convert that to a waiver or vice versa, that they similarly and appropriately amend the required density bonus report that they submit so that the correct information, because there's different kinds of information required to support a waiver than a concession. We want to make sure that whatever their final thing is that they want, they've got the density bonus report matched up.
I get that. Is that not happening? I mean, has this been a problem?
I have seen that be a problem, yes. But again, this is older days, and things are evolving.
Nicely put. So, no, I think that will be good because what it will do is it will help applicants and staff say, okay, if you're changing this, you need to give us reasonable documentation of your change.
Unless we put the and/or thing again.
No, because you have things are either a concession or a waiver. And it took us years to get that through and well understood by staff and the planning commission that they weren't the same thing.
No.
Yes. So now I'm going to ask Eric to go back and start. So take that out. I think we have agreement.
Okay.
Based on Julie that we can take that out. And then do we have further changes from anyone? Further issues?
We skipped a few sections. Do we want to go back and look at those, or were we fine with what we skipped?
I think we're fine. It's the 55-year, 99-year, or perpetuity. Did we?
Well, that's one that we know about. I don't know if we skipped anything else or not.
Yeah, that's still to come. We haven't.
Right.
Let me.
I don't see any other hands, Eric. So I think we can go forward.
Very good.
That was the only thing I had notes on at this point.
Okay, so unless I'm told otherwise, while I scroll down, I'm going to go straight to the.
I'm going to keep flipping back and forth on my screens looking for hands.
There's 3 places where 55 years is.
Yeah. Okay, I do want to clarify one issue. That when it comes to the term of the agreement, the density bonus law specifies that unless required by another law, the term for rental is 55, and for sale is governed by not a perpetual agreement, but by an equity sharing agreement, where the first owner is affordable, and then they can sell at market rate. And if there's profit achieved, that should go back to the city for making the unit originally affordable. That goes into the city's affordable housing fund. The way that I've structured this is that typically units will qualify as both density bonus and inclusionary. And so when the units are provided pursuant to the city's inclusionary zoning, then we can do whatever we want. We can make that term as long as we want. But if they're provided exclusively for density bonus, then they get the benefit of state law in that case.
Okay, but the areas that we can change it, I'd like to see the 55 be changed to perpetuity.
Okay.
I'm going to just do a check here with your colleagues. Councilmember Weinberg, do you support any change from the 55s as it's stated?
No.
Hey. Councilmember Flagger.
Mayor, could I make a comment before we take that straw poll?
Sure.
The point is that if someone were to sell it and then they sell it and you want them to get the bonus, they're hitting a lottery. It shouldn't be that someone.
I'm sorry, what bonus are they getting?
Well, then he says that they can sell it at market rate.
But
the goal is to keep our units as BMR units.
No, pardon me. We get the money. They don't get the money.
Okay, but the goal is.
There's a increase in value sharing agreement that has some of the money coming to the city. That's what I understood from Eric, and that's what I understand the situation to be.
Right. But it's a shared value, yes, but the person benefits itself. The other thing is, our goal is to keep affordable units. If we're always stating that we lack affordable units on our city, and then if we're gonna allow units to be termed out, we're always struggling to have affordable units in our city. So I just want to make that point clear. So as your straw poll, people need to understand that we need to try to keep BMR units as BMR.
Okay, Councilmember Meadows. I'm sorry, Vice Mayor.
Yes. I don't support in perpetuity. Our attorneys have recommended against that language. I would consider a 99-year term, as the attorneys have recommended, but I don't understand the need for it when it clearly says that a new 55-year term starts if the unit is sold to a subsequent purchaser. So I heard what Attorney Ramakrishnan said, but I'm having a hard time reconciling what he said versus what it actually says in this document. So maybe he can offer some explanation.
Yeah, so just to be clear, so when we're on subdivision A here, I have highlighted 55 years with respect to rental housing. With respect to rental housing, that sort of re-upping of the term doesn't happen. That's not the way rental affordable housing agreements are typically structured, and that's not the way the ordinance is written. And typically one owner will own the housing development project. It's just the ownership structure might change. But so if we were concerned about rental housing being longer than 55 years, then we could certainly have, I would prefer 99 years rather than perpetuity, just so that we're not putting a perpetual cloud on title when we don't know how the land will be used in the future. On the issue of for sale housing, what you said, Vice Mayor, is correct, that every time the property, the ownership unit sells to a new buyer, that 55 years starts over again, if the unit was provided to be consistent with our inclusionary ordinance. So in that case, it sort of does create a sort of de facto perpetual application of the affordable housing agreement unless somebody actually lives there long enough to hit the 55-year mark. In which case the policy argument for the 55 years is that person would have put a great deal of money into their home over those 55 years to keep it in good condition, and they should be entitled to some reward for it.
Yeah, so my apologies, because I had scrolled on to the second and third references to 55 years, and you were speaking to the first. So in this example then of the first, I would support 99 years. I don't support the perpetuity language in any of these instances based on our attorney's inputs.
And Councilmember Flagger.
I agree with the 99 years. I mean, 55 years, I know it sounds long, but to the extent that we can extend the period for the rental units to 99 years, I definitely support that. I proposed, because this is an agreement that gets signed, that if we were to consider adding the in perpetuity language, you could say unless otherwise trumped or preempted by law. But I hear our attorneys loud and clear. And so I would support the 99 years.
And I'll support the 99 years. So we've definitely got at least 3 there for that. And I will say no change on the ownership because the ownership does cycle over. So I think we've addressed.
Can I clarify that, please?
Yep, go ahead.
Because when the ownership, I have learned that not all agreements have been 55 years. And so that's the reason why I would like it changed to 99 years as well. So
I don't understand why you want it changed if it's because there's current agreements that weren't done at 55. We can't go back and change those.
okay, but I think that if we can change it to 99, we should change anywhere we can to 99.
And you don't get support from your colleagues on that, except with respect to the grand ownership of rental units, where we're proposing to change that to 99 years. So it'll be 99 instead of in perpetuity. And if it's an owned piece of property, whenever that gets sold, there's a new 55-year term that starts for the new owner. And
it's an evergreen clause, yeah.
Right,
yeah,
but my concern is that it shouldn't end at 55. It's 9. And any unit should be more.
okay.
Every unit that we can keep it as BMR, we should keep it as BMR.
But
You're stating that
you understand that it stays as a BMR? It does not
that's
stop
only if they sell it before 55. But if a person achieves 55 years and they sell it, they'd sell it at market rate. We get some, they get some, and it reverts to a market rate unit. It does not remain as a BMR unit in our inventory.
And I just want to clarify one thing. When you talk about we get some, they get some, that's under C. So under density bonus law for for sale units, what the legislature said that unless a different arrangement is required because of some other rule or financing source, what gets recorded is not this sort of long-term resale restriction, but instead a requirement that the original owner be income qualified and that when they sell it, the city gets some, they get some. And so if somebody is providing a moderate income units exclusively for density bonus and not because they're doing it to meet our inclusionary requirements, that is what the density bonus law prescribes. In the usual case, they will be providing the moderate unit because we require moderate units for for sale projects. And in that case, we can set the requirements. And so we haven't said, what's written here is not the equity sharing arrangement. What's written here is that for 55 years, it's restricted. If it's sold within that 55 years, we reset the clock at a new 55-year term. Somebody actually owns the unit for 55 years. Because the house has a 55-year useful life, they will have put so much money into that house it will be almost as if they've rebuilt it over the course of that 55 years. And so they get all the benefit of that. That's what's written here. So if something else is intended by the council, I just want to be clear what's written here.
You have to understand that when someone gets a BMR unit in a desirable area at a BMR rate, they have received benefits overall. And so it's a pride of ownership that you take care of the ownership of the unit.
And
So that's,
Councilmember,
yeah.
I'm sorry, I want to be clear that I'm not dictating what the policy should be. I'm just explaining what the current language says.
Okay, but
So if you had a different intent, I wanted to be honest about what the current language says.
okay, but we have a right to change it. I'm just saying.
Yes.
We do have a right to change it. And I think the way you're presenting it, it's like discouraging people from changing it. So I think it's not clear that we have a right to change it, and we can keep it and change the years there for the term.
Okay, so I'm going to go back through my colleagues and ask 2 questions, starting with the vice mayor. You understand that we could increase the 55-year term on individually owned affordable units?
Yes, Mayor.
Would you like to do that?
No, Mayor.
Councilmember Flagger, same 2 questions.
Ditto, ditto.
Councilmember Weinberg, same 2 questions.
Ditto, ditto.
Okay, so we have heard Councilmember Lee Eng say that she thinks we should basically continue the benefit sharing after 55 years. And at least 3 of our council members do not want to change that and want to retain the language that is here. So we will move on.
Mayor, what's your thinking on this? I just want to make sure we hear you weigh in on it as well.
I would probably stick with the 55 years on the premise of useful life, because these are mostly, what do I want to call them? Condo type arrangements, condo or townhouse type arrangements. And if someone's actually been in one of those for 55 years, part of the problem here is what happens with the whole building. And so to try and differentiate what one person can do and make a different rule, I think is a real weird problem, creates a different problem.
My goal is to protect BMR units.
I understand. Okay, so now we're through the language. So is there any other language that anyone wants potentially to change before we take a break? I'm going to ask Eric to please scroll down here. Just keep scrolling, keep scrolling, keep scrolling. So what I would suggest, keep going. Keep going. I think we're near the end, right?
Yes.
Okay, keep going. That's the concessions. Okay, what I would suggest is that at the beginning of this appendix, that we indicate, so if, and I know this is in the text, but I would put it at the top of the document as well. An appendix to affordable housing ordinance to indicate that this is provided for convenience and may not reflect every possible benefit, or I don't know what the right words are, that are available under the law, and to consult the actual current law for other possibilities. Just because I know this has the majority of it, but it doesn't have all of it.
So I've got this appendix as a summary of current state law and is for reference purposes only. Applicants are encouraged to consult government code section 915 for further information about state density, this should be covered, density bonus law. Does
And
that,
you can cogitate on that while we take a break.
okay.
Okay, but you understand what my suggestion is? I understand that the text of the ordinance refers to this and says why it exists. Maybe you can just grab that and stick it here, but I think for since we're into eliminating ambiguities and preventing questions, that it would be a good thing.
And I think I see hands, Mayor.
Okay, Vice Mayor.
Yes, since we're beefing up the caveats, that you could use whatever the standard one is in case of conflict between this document and state law prevails or whatever.
Yes.
Not that I'm turning into a lawyer after this long. I'm halfway there.
And Councilmember Weinberg.
I was going to say the same thing as the vice mayor. I would also suggest that after section 65915, we add language to the effect of or any successor statute or something to that effect.
Yeah, we usually say or as amended from time to time or something.
Right.
And Madam Mayor, if you like, before we go to break, I'm happy to make a motion.
I think we wanted to give Eric a chance to go back and look at a couple of things during our break and see if he wanted to change any other language. I want to give him that opportunity. I feel like I promised him that opportunity. I should give it to him.
Yes, two things to point out. One is that I would like to use the break to come back with a more concrete proposal because I don't think we closed the loop on this language. And I just want, for the public's benefit, when I changed A and B to 1 and 2, then the preceding A and B changed. So I'd like it to be understood for the purposes of today's meeting that please pretend this is 1 and 2, and I will work with my word processor tomorrow to figure out how to make that happen.
Your cat stepped on the wrong key. I know.
Probably.
All right, so I'm going to, it's 9:29 by my clock. Let's take a 10-minute break and reconvene at 9:40. Thank you. Okay, it's 9:40. Do we have the Vice Mayor and Councilmember Flagger with us? Okay. I noticed that Mr. Ramakrishnan took down the screen share, so
Yep.
did you get it all worked out?
I think so.
Okay, let's call back into session then.
I want to reiterate that I realized, I apologize. I want to reiterate that I realize the numbering is still off and that will be fixed. And it's understood that the correct numbering should be here. What I would propose, and I know this is extremely detailed, but I feel like it has to be. I went back to majority, but I made it a new sentence for clarity. So majority of the units shall be designated at moderate level period, the rest low and or very low. And then down here, I created a new subdivision D to define majority. So if 50% of the affordable housing units required by subdivision B results in a number with a fractional remainder, then the term majority means 50% rounded up to the nearest whole number. But if 50% results in a whole number, then majority means 50% plus 1 unit. I think, even though that's complicated and detailed, it's the only way to do it. Please let me know if you have comments.
So I'm looking for hands. I see thumbs up. So I think we're good to go.
Okay, and I just wanted, I decided to fundamentally keep this the way I had it with non-substantive changes. I just want to make sure that's okay with the council.
Okay, everybody okay? Looking for nods, thumbs.
Just clarifying, earlier,
Yes.
Ms. Houston mentioned instead of stating successor statute.
As amended, as may be amended.
Yeah,
With
I
the
think it would be
phraseology sheet.
clearer to state that because a statute is a different, not everything is going to be captured as a statute. Any amendments not captured as a statute. So I just want to make sure.
I think we let the two city attorneys work out how they want that language to be.
Yeah, we'll arm wrestle over it or something.
Okay, you can arm wrestle over that. That being the case, can I get a motion on item number 4? Councilmember Weinberg.
Thank you, Madam Mayor. I move that this council adopt ordinance number 2022-blank, which is included as attachment 1 to agenda item number 4 of tonight's packet and is entitled An Ordinance of the City Council of the City of Los Altos, amending chapters 1.12 Appeals, 14.02 Zoning, General Provisions and Definitions, and 14.28 Multifamily Affordable Housing of the Los Altos Municipal Code, of the Los Altos Municipal Code, as amended by the council during tonight's proceedings, and that the council categorically find that this action is exempt from CEQA.
And we need to say that this is introduced and that we waive further reading, I think, if you'd accept that.
Yes.
Okay. And a second? Councilmember Liang?
Second.
Councilmember Liang seconds. Deputy City Clerk.
We have a motion on the floor. If you agree with the motion as stated, please say aye. Councilmember Weinberg.
Aye.
Councilmember Fligor.
Yes.
Councilmember Liang.
Aye.
Vice Mayor Meadows.
Aye.
Mayor Enander.
Aye.
Motion passes unanimously.
And I have a request for Ms. Simpson, since she has the unenviable task of managing our housing element process in addition to implementing all of the changes we make between now and whenever. And that is to capture, for purposes of reporting on our housing element, that we made a policy change tonight with respect to the term of affordability for rental, and that we ask that the term of affordability on for sale units be potentially considered when we are reviewing policy for implementing our next housing element.
Okay.
Thank you.
Thank you.
And now, the other order of business I want to take up is that we normally decide whether we're going to try and plow through the remaining material. We have an hour and 15 minutes until 11 o'clock. Do you all think we can get through these? Okay, you willing to hang in? All right, then we'll get through everything else that's still on the agenda, taking up item number 3 that was pulled from consent. Mayor Lee, or excuse me, Councilmember Lee Eng.
Thank
You
you,
had
Mayor.
issues?
Yeah, as I spoke to the city attorney today, I had some clarifying questions regarding what should be under section 3 of the ordinance. And on our signage, I'm pulling up the picture of the sign I took on the what we had stated. I was asking about limitation of dogs and just to address some of the concerns people have. So I wanted to capture it in writing. So then I asked about, would we be putting it in section 3 of the ordinance, such as limiting the amount of dogs? Because our signage stated that we had a maximum of 3 dogs per handler. And I think things like that should be clear and placed in our ordinance. I also feel that we had things like the age limit, that no accompanied minors less than 14, and they should be supervised by an adult. I think some of the main ones should be in this ordinance. I went to a dog park to check out other dog parks, and we have a very small dog park that we're implementing in our city. And when I attended the dog parks in the neighboring city, within that short time I was there was 3 dog walkers. One guy brought in 9 dogs. Another individual brought in 7 dogs. Another very limiting. And what we want is to ensure that our community members have an opportunity to enjoy these fenced-in areas.
Thank you. We did discuss that in approving it the first time, that we were going to leave that to staff. And I see that city manager has turned on his video. That's usually its hint that he wants to say something. Mr. England?
Yes, Mayor, that's correct. Staff intends to draft the rules and make them clear. Council did make some of their preferences clear at the last meeting, including limiting the number of dogs that one person can bring in, as well as the age limit and as well as the time spent. So staff is prepared to draft those rules prior to the opening the dog park.
Okay.
I think that when we have it captured in our ordinance, it assures our public that we've got some items very clear and that we want to adhere to that clearly.
So you are welcome to make a motion that you want to amend the ordinance.
Okay.
But I don't know that you will get support elsewhere for that change.
Okay, I'd like to make a motion to amend the ordinance to clearly have an amendment to clearly articulate the limit of dogs and to have that age limit requirement much similar to what we had on our signage earlier when we had the off-leash program.
Would there be a second? Seeing no second, is there someone who would like to move the item? As stated, yes, Councilmember Weinberg,
So moved.
is there a second?
Second.
Vice Mayor Meadows got her hand up first, so we have a Councilmember Weinberg moved and Vice Mayor Meadows second to hold second reading and adopt an ordinance amending Los Altos Municipal Code Section 5.08, authorizing the off-leash fenced-in dog parks in accordance with the consent calendar item number 3. Deputy City Clerk.
Thank you, Madam Mayor. We have a motion on the floor as stated by the mayor. If you agree with the motion, please indicate so by saying aye. Councilmember Lee Ang,
Aye.
Councilmember Flygor,
Yes.
Councilmember Weinberg,
Aye.
Vice Mayor Meadows,
Aye.
Mayor Enander.
Aye.
Motion passes unanimously.
All right, then we'll take up item number 5, the Council Legislative Subcommittee. And I believe that Councilmember Flygor, you're probably going to present this.
I am, Mayor. Thank you. And of course, we have the city attorney to answer any legal questions you may have. And I plan to pull a John Maginot where I say the report has been submitted. Let me know if you have any questions. I will go through each of the questions we have presented just to guide the discussion. But before we do that, any questions based on the memo that we submitted?
Councilmember Lee Ang.
So there's one thing I need clarification on. If a subcommittee meets, does it need to be posted or noticed? So I'm just asking in general if a subcommittee meets.
So I will have the city attorney answer that question.
So if it's an ad hoc subcommittee that's just formed for a limited duration and a limited subject matter jurisdiction, it does not need to post or have it open to the public. But if it's a subcommittee that's formed by the city council, it has a fixed subject matter, ongoing subject matter that is usually goes over a year in meetings, or the meetings are set by the action of the city council, then that's a standing committee, and it needs to be noticed and have an agenda and allow the public to come and participate. So,
Thank you.
you know, ad hocs are usually like the police facility. There's 2 people, they go, they do the research, and they report back. But it isn't going to go on and on and on for years. But the legislative committee, it's oh, I might have just jinxed it. Oh no. But you know, the legislative committee, it appears that it's going to be an ongoing, you know, because of all the bills and having 2 council members review the bills and continue to meet on a regular basis. It is really a standing committee, and you should think of it as a standing committee. So, and you know, and that will also allow more participation. And years ago, we didn't have as many bills that we, you know, especially the land use and environmental bills. But I think this is the wave of the future. We're going to have, I think we're going to need the legislative committee in the future.
Thank you, Ms. Houston.
Any other questions for Councilmember Flygor? Okay, go ahead.
public comment and then discussion, Mayor?
All right, so Deputy City Clerk.
Yes, if you would like to speak on this item, please use the raise hand feature. We have one thus far. Anyone else, please raise your hand so we can take into account.
I think we have only one, and I'm gonna guess that she can say what she has to say in less than 3 minutes, so go ahead.
Roberta, are you there?
Yeah, I'm here. And yes, less than 3 minutes for sure. I think we should have a standing subcommittee. We have laws coming down from the state on land use and the environment, climate change. And I think it's reasonable to have the public be involved and to be noticed as part of the education of the community. And I just support a standing committee and hope that this can be passed very quickly tonight. Thank you.
Thank you. And I don't see any other hands, so coming back to Councilmember Flagger.
Thank you, Mayor. And as I said, I'll just go through each of the 5 questions to guide the discussion. And if there's no need for a discussion, we can obviously entertain a motion because I'm presenting it. I'd prefer not to make the motion. So the first question is, should the Legislative Committee be a standing or ad hoc committee? Any discussion on one over the other? Okay, so the question then would be, is there a consensus that we should continue or formalize or a legislative subcommittee as a standing committee? Everybody nod? Okay, great.
So I'll go around. Is there general consensus about it continuing as a standing committee? I'll say yes. Okay. So I think that answers that one for you.
Thank you, Mayor. The next question is how to format the subcommittee's presentation to council. And this is really attempting to address some concerns that were raised last year. So 2 of the recommendations that came out of the last time we discussed this were, 1, to have any materials or presentations provided to the full council 72 hours before the meeting, and the subcommittee members providing arguments both in favor and against any bill being proposed if that information is available. And so I'll leave it up to you, Mayor, how you want to get feedback on these 2 proposals and or any other suggestions on how the subcommittee presents to the full council.
So does anyone want to comment about that?
So, okay.
Go ahead, Vice Mayor.
I was just going to say, I think both those points are reasonable and would reflect what we've observed or requested as we've talked about this in the past.
Councilmember Liang.
I think the number B bullet earlier when it was stated on providing clear information, like if we provide just clear bullet points of what the bill is, I don't think it's necessary to present 2 sides, because sometimes it's not clear that there are sides. If there's an introduction of a bill, you just got to give the factual points. And I just think that stating that provide arguments in favor and against a bill right now is not necessary. I think that it can be, when the information comes up, if you want to ask for clarification, I think you can. But, I think just providing clear bullet points based on what the bill states, and it will be straight from the bill, just making it easier to read, would be clarifying enough.
I guess I have a question for, go ahead, Councilmember Flagger.
Oh, thanks, Mayor. I just wanted to respond to Councilmember Lee Eng's point. So I understand that especially early in the process, when a bill is first introduced, you may not have arguments in favor or against. Like right now, a lot of bills are being introduced and we don't know what the opposition will look like to many of these bills. And so that's why I think an important piece of this is if the information is available. So I agree with you if it's at the early stage where you just want to have it on our watch list, like you're bringing it to us saying, this is what this is, and you really don't have arguments against the bill at that point. That's what this covers. If it's not available, it's not available. But to the extent a bill is being proposed and there is information in favor and against, regardless of what the specific bill states, then that's something I think needs to be brought to the full council for us to make a decision.
Councilmember Weinberg, go ahead.
Thank you, Mayor. What Councilmember Flygore just said makes a lot of sense to me. Perhaps the rule should be that if the subcommittee is going to recommend that this council take a position on a bill, at that point, it should be incumbent upon the subcommittee to say, here are the arguments in favor of the subcommittee's recommendation. Here are the arguments in opposition.
Right, or the other possibility would be, and this has happened, where the different members of the subcommittee have different perspectives, in which case they would each potentially present a proposed position or letter in favor of whatever their position happens to be. But otherwise, the council member read my mind, which is if the subcommittee is bringing a proposed position, then we know enough, should know enough to be able to present both. And otherwise, if it's just like, this is as much as we know about this bill right now, it does this, this, and this, and this, then, you know, there isn't anything really to show. So that would be I'd agree with Councilmember Weinberg on that. Anything else on point number 2 that anyone wants to raise? Okay, you want to move to number 3?
Thank you, Mayor. The next question is, how can non-legislative subcommittees members ask that the legislative subcommittee consider a bill? And so 2 suggestions here. We can make the request like we do for other agenda items during the future agenda item discussion, or non-legislative subcommittee members can request the bill to be added as an urgency item. And there's a process for that I know the city attorney can explain. But basically at the beginning of the meeting, you would ask that, you know, this urgency bill be considered because of time and urgency concerns. It needs to be considered by council at that meeting.
I would make one possible addition to that, and that is to make it clear that requests to add a bill would not be limited to other council members, because I know we've had the occasion in the past where the city attorney asked that we follow a bill and potentially take a position on a bill. And so it should be, and it could also be done under future agenda items where staff would ask that something be tracked and potentially something come forward from council. Yes, Vice Mayor.
So I'm wondering, we haven't talked about the option. I mean, obviously it makes sense to put something in future agenda items, but can't it be a standing agenda item within the legislative subcommittee's report where we add, rather than separating a bill that we want to track and having to bring it up during future agenda items? Usually they're going to be close the way our agendas run and timing, but it seems artificial to separate it if we don't have to. So I just thought I'd bring that up.
And if I can respond, that assumes.
I like that, and then because then we can just have so you'll be able to add it without making it an urgency.
Yeah, and our practice well, I have been on this for 2 years. I don't know that they ever had one before that, but for those 2 years, our practice has been, once the legislature's in session, that we had a standard place on the agenda. And so I think that's probably, you know, that would be my preference. And I see heads going up and down, so I think that would be.
I agree as well, especially if it becomes a standing item.
Yeah, I think it's just during the legislative session. And then we leave it as a standing item. And then what we did in the past was if we didn't have any actions proposed, I think there was 1 or 2 meetings where we asked Andrea to pull it off the agenda. But I think by practice, we would simply leave it as an item. And if there's nothing, there's nothing, but it leaves then the place for there to be an addition if something has come up. Go ahead, Councilmember.
Thank you, Mayor. The 4th question, can the legislative subcommittee take a position on a bill on behalf of the city council if the full council has not taken a position on the bill? And, you know, the options here are yes, within certain parameters, or no, you know, even if it's a word change, we want it to come back to the full council for us to give direction. And if it's no, then the memo has 2 other suggestions about how we can handle that going forward. So if you want to break up the questions, Mayor, so first, is it yes or no in response to the legislative subcommittee being able to take a position on a bill if the full council hasn't taken a position? And this would factor in amendments to the bills. For example, as you know, the earlier version, we may have taken a position on and then they changed something. Do we want you to bring that back to the full council?
Yeah, and I think this is where it gets a little bit tricky, because if there's been, not a huge change to the bill, and yet there's a request, and very commonly what happens is it's moved from one house to another and there hasn't been a substantive change, but to be counted, we actually need to send in a separate letter once it's in the other house. So if it's not a substantive change, could the committee go ahead and do that or not? That would be one possibility. For me personally, if there's a substantive change, a really substantive change, I think it should come back to the council. And I don't think that we send any, certainly the subcommittee doesn't send any letters, at least early on, without council having had a chance to look at them. It's just not a good idea. As we do, I mean, we've chosen as a city not to do what many other cities do. Many other cities either have a lobbying firm who drafts the city's basic platform, if you will, of what the city wants represented. And if there's a bill and the bill is consistent or inconsistent with that, they just do the letters. Or they do that without the lobbyists. They do that as a city council action. They have a platform at the beginning of the year, and then the committee just functions based on that platform. We don't have either of those two at this point. The closest thing we have that we could look at would be the platform that the League of California Cities has. And we could always say, here's the League's platform. If it's consistent with the League's platform, then the committee could act, but that's the only possibility I can imagine. So, Councilmember Liang?
I recall that the subcommittee never took a position. They presented it to council. Council took the position, and it was the mayors that sent out the letters. So it would be consistent like when you were mayor. Yes, there may be minor changes to a letter, or a same letter went out, but of course you're just going to change the titles and houses or Senate names to it. But it was never the legislative subcommittee that took a position. So correct me if I'm wrong, Mayor. That's not even something that needs to be asked, because it'll be consistent to how we've conducted business.
Councilmember Flagger?
Thank you, Mayor. I just wanted to clarify the point. So you're correct, Councilmember Lee Eng. The mayor would sign that letter. The issue this is trying to address is, for example, if there's a bill that hasn't come to the full council, but the legislative subcommittee meets and thinks, as a city, we should take a position on the bill. The legislative subcommittee on its own could not then draft a letter and send it to the mayor to sign. So that is what this is attempting to address. Basically, for the legislative subcommittee to draft a letter for the mayor to sign, that position has to be approved by the full council. I do agree with the mayor that if it's just a change in the House and it's the exact same bill, to me, that doesn't need to come back to the full council where we're just changing names on the letterhead. I do think if we try to define what substantive means, that could take another 4 hours. And so my preference would be to say any change to the letter, notwithstanding the, the changes to the names and things like that, then that should come back, because unfortunately, one word change could actually change a lot. And so that would be my suggestion. But I agree, if we're to set any parameters, is exactly what the mayor said. If it's just changing from, assembly to the Senate, it's the same bill. And it shouldn't come back to the full council.
Councilmember Weinberg?
For the most part, I think I'm aligned with what Nisa just said, but I just want to be clear that there's an understanding that if a bill is going from one chamber to the other, the subcommittee is not being authorized to just change the title and send the letter out if there has been any change to the bill as it worked its way from one chamber and is now moving to the next. So just because the council approved a position on Bill X when it was in the assembly doesn't mean we want to take the position on Bill X when it goes to the Senate if the assembly has voted to amend the bill. I think if there's been any amendments at that point, that it should be clear that the subcommittee doesn't have the authority to go ahead and send a letter out. And I think it's also important to make clear that the difference between this year's subcommittee and the past two subcommittees is that the mayor is now a member of the subcommittee. So it's not, there isn't a check and balance, I think, that we had in the past 2 years. And that's a concern to me.
I'm not sure I understand your comment.
I think when you had a subcommittee that did not include the mayor, you had two council members who were putting together a position paper, a letter representing the council's position on an item. Those two members then gave their report in the form of a letter to the mayor, who acted as a check to make sure that what the subcommittee has said is in fact what the majority of the council has said. And that check is missing this year.
I can't imagine.
So I think I know what Councilmember Weinberg is saying, Mayor, but I don't think we have that issue. So I think what Councilmember Weinberg is saying is, in the past, you would have the subcommittee draft the proposed letter, present it to council. The full council would vote on the letter, and then the letter would go to the mayor to sign off on it. When I was mayor last year, I would definitely triple check to make sure that the letter I'm signing is the letter that was voted on. And I think what he's saying is, you're part of the subcommittee. You would be sending that final draft letter to yourself to sign, and would be able to sign off on it. We all get a copy of the letter. The norms require that we get a copy of the letter. And I normally, triple check. So I think we're covered there.
Yeah, I think so. And the other thing I wanted to be sure we were clear on was that I understood what Councilmember Weinberg was saying is if the committee and the recommended and the council took a position on a bill and sent a letter, and then that bill is not changed subsequent to that date and then moves to the other house, then the same letter could go. But if the house to which the first letter was sent amended the bill after the date of that letter, then the committee would come back for a change before sending a letter to the other house. Is that a correct statement, Councilmember Weinberg?
I think you just got promoted, Jonathan.
Yeah, close. So I get for having a conversation earlier today. Never mind. Councilmember Lee Eng.
So I hear what you're saying, Councilmember Weinberg, but then I want to make clear that all these concerns that we're raising here regarding the legislative committee also applies to our representative on the city's association, that our council position is consistent and represented. So just like what you're raising concerns here, my concern is, well, if you want to make sure there's a check and balance, we don't have that same thing representing. We have you push to nominate a council member to be on the board, and so
Council member, I think that's
out of, I think,
scope of
okay.
the conversation.
I'll put it as a future agenda item, but I'm going to raise this concern again at future. Thank you. But I'm just concerned what was raised, and all the letters come back to council and it's somewhat accusatory, and I'm just concerned about that.
Thank you. Go ahead, Councilmember Flagger.
No, and if I may, whatever rules we agree on tonight, these rules will be in place for any future legislative subcommittee.
Yeah, unless we change them again. And I think we'd all agree with B2, council members can always take a position in their individual capacity. As long as it's clear that that's their individual point of view. Number 5.
Do we want to establish any criteria for the types of bills the legislative subcommittee should consider? And I remember the vice mayor had raised this based on the number of bills that the legislative subcommittee brought forward last year. So I presented 3 different options for us to consider. One is only bills that clearly directly impact Los Altos. The second is only housing bills, since most times that's the bulk of the bills. And then the third option is all bills that the subcommittee deems relevant, even if they don't directly impact Los Altos.
So I'll start by saying my temptation is to say number A. However, I want to be sensitive to, and I'm going to go to potentially C here, because I want to be sensitive to the fact that as a member of the League of California Cities, we are sometimes asked to support the league with letters where it may not directly, that we can see, have a huge impact on Los Altos. And yet as a responsible member of the organization, it can be helpful to the organization to sign on to a letter. And that is the one circumstance I can see where we might want to take up a bill that's not something that we see as having a big impact on Los Altos. So that's my opinion. Vice Mayor.
I agree with that largely, though. Again, I think that the council as a whole should agree with those C-related issues. Because just because the league asks for an opinion doesn't really mean that our opinion adds that much if it's not directly related to Los Altos. I don't have any hypothetical examples to suggest so, but yeah, so I agree with A and C as relevant. I think that's basically what you said too.
Councilmember Weinberg.
Ditto what the vice mayor just said. I just want to throw out there, though, that the League of California Cities, while being an incredibly important resource to us, represents a lot of different cities with a lot of competing viewpoints and agendas. And I think that it is conceivable that the league would recommend a position that may not be in the best interest of the city of Los Altos. So even if the league is recommending something, I don't think ipso facto it follows that if it's going to affect Los Altos, we're right away going to write that letter in support of the league's position. I think we still have to take that step of coming to council to ensure that what the league recommends really is in the best interest of our city.
And I think we'd be asking the subcommittee to use its judgment that if the league has asked for a letter and it's something that does not appear to be of earth-shaking import to the city, that the subcommittee has to make a judgment of whether to take up both their own time and the council's time in bringing forward a letter. So Councilmember Flagger, do you have a way to want to wrap this up?
I do, and I just want to echo my support for C as well. Leave it up to the subcommittee to make that determination. Even if it's not directly applicable to Los Altos, it's still something that you think we should consider. So I've gone through the 5 questions that we put together in the memo. If there are no additional questions for consideration, then I would encourage or entertain a motion from one of my colleagues, wrapping this all up and incorporating the changes that we agreed on today. Thank you.
Councilmember Lee Eng.
Councilmember Weinberg had his hand up first. You better take
Thank
him.
You, Councilmember Weinberg.
I'm sorry, before you entertain a motion, Mayor, I just want to clarify one thing. I should have done this earlier. If the legislative subcommittee is going to make a standing subcommittee that is subject to the Brown Act, that's where the council wanted to go, right? Okay, the last time we talked about this, the subcommittee took the position that other council members should not be allowed to attend their Brown Acted subcommittee meetings. Is that the position of the council, that council members aren't allowed to attend? Is that even legal?
Councilmember Flyer, you're shaking your head.
No. Yeah. So, it's a very strange rule, but if you have a Brown Act standing committee and it's a noticed meeting, so other members of the council can attend, but the Brown Act says you can attend as observers only. You're not allowed to speak or participate. It's a very strange rule. I don't know if it's ever been tested, but that's what the Brown Act currently says. So you can attend and listen, but you're not to speak or participate, because then you've got a majority. So anyway.
Okay, Councilmember Liang.
Item number 6, any other questions that council should consider? We can always consider obtaining a lobbyist again when there's so much distrust in your fellow council members, because I've repeatedly heard some statements made that that I find troubling. So if you want, I think we could also further consider a lobbyist to take on this role. And I think that would be worth discussing.
Member Flagger.
I think that's
were you going to say something?
I was just going to say, I think that's a future agenda topic. Isn't that, I would say that's a future. I don't think it's included in this, but if you want to discuss it in terms of this legislative committee, I think you'll be able to discuss it, or otherwise we can bring it back as a future agenda item, and Councilmember Lee can suggest it as a future agenda item.
I think she was just pointing out and repeating something I'd said, which was some cities that's what they have, and that's how they deal with this. So, Councilmember Flagger?
No, I agree with the city attorney. I think it's a separate, if what's being proposed is hiring a lobbyist, I do think that's a separate item, and I won't go into giving my feedback and comment on that proposal. It would have to be tied directly to the legislative subcommittee that we're discussing, and I think it's a different request that Councilmember Lee Ang is making. So I do think it's outside of the scope of this item.
I'm not sure I heard a request. I think it was an observation.
Okay.
So are you prepared to wrap this up into a?
I would prefer if one of my colleagues made the motion.
And I've just somehow managed to do something horrible to my screen, and I've lost. There we go. All right, so Councilmember Weinberg?
All right, let's see if I can put this all together. I move that the council confirm that the legislative subcommittee is a standing subcommittee subject to the provisions of the Brown Act. That the legislative subcommittee shall provide materials at least 72 hours in advance of a scheduled meeting. And that the subcommittee shall provide arguments in favor and against the bill unless information is not available, but shall in all cases present an argument in favor of or against the bill if the subcommittee is making a recommendation that the council take a position on a bill. I further move that someone who is a council member who is not a member of the subcommittee may request during future agenda items.
I think what we talked about was leaving this as an agenda, a regular agenda item during the session.
Okay, leave it as a regular agenda item during the session, but that council also allow the city manager or the city attorney to make a recommendation that a bill be considered by the subcommittee. That the subcommittee shall not take a position on a bill on behalf of the council without full council authority unless it is to submit a letter to a different house for a bill that has not been amended by the first house. And that the subcommittee shall focus on bills that directly impact Los Altos, but may use its best judgment in considering all bills the legislative subcommittee deems relevant, even if they don't directly impact the city of Los Altos, with the understanding that the council can easily get overwhelmed with too many bills. Am I leaving anything out?
I think maybe only whether there's an urgency possibility. I'm looking back at 3B.
And that goes without saying, Mayor. This was just a prompt
Right.
to say
There's a normal, we have a normal urgency provision, so then I don't think we need it in the motion. Just wanted to double check. So I would happily second the motion. And thank you, Councilmember Weinberg, for doing that lovely summary.
We now have a motion on the
City Clerk?
floor. Yes, as beautifully stated by Councilmember Weinberg. If you agree with the motion, please indicate so by saying aye. Councilmember Flagler,
yes.
Councilmember Weinberg,
Aye.
Councilmember Lee Ang,
Yes.
Vice Mayor Meadows,
Aye.
Mayor Enander,
Yes, and with thanks to Councilmember Flagger for putting this together.
Motion passes with a unanimous vote.
All right, we're moving to information items. And let's see, can I count on the city manager for item number 6?
Mayor, the information item on Alta Housing, is there any specific information you would like on that?
Let's see, I guess only to ask if anyone has any questions for the city manager or for Ms. Simpson. And pointing out that there was some information provided in answers to council questions. So Vice Mayor, go ahead.
Yes, I have a question. I apologize. I didn't ask this in council questions, but on the second page of the report at the top, it says Alta has recommended this for the past few years. And I wasn't sure what this referred to, so I couldn't quite tie it in with the previous, because it felt to me reading the report that there was an open loop, that the previous council had met with Alta and the pandemic came up and something was intended to happen and it didn't. And so I didn't know if that the Alta has recommended this for the past few years and participated in a study session with some council members in 2019, if that was meant to be identifying what that open loop was. And then we might need to consider under future agenda items whether that's a loop we want to close.
Vice Mayor, I'm happy to follow up with Alta Housing and get clarification.
Okay, so they wrote that Alta has recommended this for that was.
And I'll just add that I had the same question, and my best recollection, and my other colleagues who've been on can remember as well, I think that had to do with reestablishing an agreed priority set of priority categories and process for, deciding who had priority for what and that kind of thing. But that's my memory, which, that's more than a couple years ago. So
Mayor,
Councilmember Lee Eng, I think you were next.
I think Councilmember Flagger had a response to your questions or concerns. So I wanted to hear the answer so we don't skip over it. So, okay, you lowered your hand? Okay.
Yeah, I was going to echo what the mayor said. I know our city manager wasn't with us in 2019. And the vice mayor wasn't on council. A very similar thing happened back then where we got a report, and based on the report, we had a lot of questions. And so the direction was, let's actually schedule a meeting where we discuss all the different things that came up as part of because the Alta House submits these reports periodically. And so we have not had that meeting yet.
So, and just for clarity, I want them to tell me what this is, because they could be referring to the priority ranking, which was in their memo. The list after that was from us, which are examples. So I just want to see clarity from them.
Okay, yes, Councilmember Liang.
So my question is, and if you're following up with them, can you find out if there's any violations of the BMR agreements that they've identified? And if so, how many? I know in the past we've had issues with some people violating BMR agreements. And so I just want data like that to be brought to our attention as well. Thank you.
Happy to follow up, Councilmember Liang.
Councilmember Weinberg, and then the vice mayor.
Thank you, Madam Mayor. I'd like to be sure that when Alta Housing is reaching out to the school district, when BMR housing opportunities become available, that they actually reach out to all 4 of the school districts that serve the city. And I also want to make sure that they're letting city staff know as well. I think in the questions to council, there was a statement that it was that Altos did let one or two directors know, but I want to make sure, maybe they should let the city manager or the associate city manager know so that we're sure everyone in staff is aware that there's an opportunity.
We can make that change, Councilmember Weinberg.
Thank you.
Vice Mayor?
Yeah, I was just gonna, I'm gonna say this, even though we're making the housing element bucket a very large bucket overflowing with ideas, but I mean, there may have been a loose end, but I also think there's a lot of questions as what we see today. And so I think it could be worth revisiting and make sure how this is being done matches up with the goals that we're outlining in the housing element. So, I propose that as a future agenda item, or at least a slot into there. And I know, as I said, it's a very big bucket already, but I can see it really lining up with helping us achieve what we're trying to do.
I'm going to echo what several of you said. We do need to I think we need to review whatever they're using as their priority setting approach, and either concur or change that. I'm a little uncomfortable with not having a waiting list. We do need to be sure the other school districts are being touched, although it's possible that at the high school level, there's nobody who actually qualifies. I'm not sure about that. But I'm sure there are people who qualify at the elementary school level. And what the vice mayor said about the housing element. And I think Ms. Simpson is still on the call. And if she isn't, I know that the city manager can add this to her ever-flowing bucket.
I'll add it, Mayor. Thank you.
And I agree also with Councilmember Lee Ng's queries about, do we have any problems? And if they have addressed any problems in the last couple of years, we should know that they've addressed problems. So I'm not just, currently is everything copacetic, but have they had to address any problems? Councilmember Flagger.
Thank you, Mayor. I think this is now evolving into a discussion. And this is what happened the last time, where it was a report presented for informational purposes, because we all have suggestions about how they can improve things. And so I think what makes sense is to do this as a future agenda item, because now we're giving direction. Yep. Yeah.
City manager, have you got everything you need?
Yes, Mayor.
Okay, good. Then let's go to tentative council calendar. Councilmember Weinberg?
No, I'm sorry, nothing. Never mind.
Okay. Councilmember Flagger?
Thank you, Mayor. I noticed that we don't have Distal Circle on our tentative calendar, and I wonder if it just dropped off inadvertently or what happened there.
Councilmember Flagger, this is City Clerk Andrea Shalamangos. I am not sure. We will check into that and get that back on the calendar.
Wonderful, thank you.
I think they're going to be coming back for a story pole exemption. That's the latest.
Just to make sure it's on the tentative, so it doesn't get forgotten.
No, it won't. It's going to be coming back.
City manager, do you want to go over anything about this, or are you just on the recipient side right now?
I don't need to review anything, Mayor.
Okay.
Items like Distill Circle, items like that. So we usually allow them if it's the applicant or the entitlement process pushing the schedule, not to include them in the tentative. But as the city clerk said, we'll follow up and make sure that it's their process to move forward right now.
Councilmember Liang?
I just had a future agenda item I wanted to inquire about. I think at our last meeting, we talked about how would we address the labor court item coming back? And then Councilmember Weinberg stated that he had some interest in how we would agendize that. And so I just wanted to follow up on if that has been resolved.
I'm not sure I know what item. you're
After a
referring to.
representative or a neighbor of the labor court came to council last time, she requested that we agendize it, her concerns for discussion. I think they had some concerns regarding the brightness or some things we need to address in our objective standards. And I didn't know how we would try to achieve that. So
I think the city manager met with the person concerned, and I'm not sure procedurally here what we can talk about and what we can't. So
okay, I just needed to know if it was coming back. The other question or the other item
do you want to hear an answer from the city manager?
yes.
So Councilmember Liang, we concluded that topic. We sent a summary email to council. I'm happy to send that again, and then we can go from there. It
Okay.
suggested how the item could be or could not be scheduled.
Oh, okay, I'm sorry, I missed it. Thank you. Then the other thing I'd like to possibly put on for future, or I'd like to add for future agenda, is a discussion on how our representative at our cities association is going to represent the interests of our city and positions taken there. So I would like that for discussion.
And are you seeking that items that are known issues at city come to us for discussion?
Correct.
So you're looking for a presentation from the city's representative about the open issues and things that we might want to weigh in on, or something else? I'm not sure.
No, it's how our representative who represents us at the cities association and what positions to make sure it's in line with our positions as a council. Otherwise, positions shouldn't be taken.
I'm still not sure I know what you're asking us to do.
Okay, I'll reframe it and I'll bring it back next meeting.
Okay. We do have a council norm that everyone who represents us on outside boards reflects any positions that the council has. What we may not have, and maybe this is generalized, what you're trying to get at is, do we have a process, or how do we make sure that people on those boards are coming back to council if there is a need to get direction from council? And so, but I don't want to guess here. And Mayor or Councilmember Flagger, do you want to comment?
No, Mayor, this was on something else. I thought you were wrapping this one up.
Yeah, and I don't want to just try and guess and put words in anybody's
No,
mouth.
so just to clarify that, positions are being taken on legislation at cities association. So if we're concerned about the legislative committee and the positions taken, then that should be consistent with our representative at the cities association.
Okay, got it. Anybody else on tentative calendar items? Okay, how about staff reports? Or I'm sorry, Vice Mayor, are we on to reports and information items? Okay, I'm going to take Councilmember Flagger and then Vice Mayor.
Thanks, Mayor. So my question, I don't think Mr. Maginot is on, so maybe the city manager can help with my question on office hours. I was asked by a resident if we were going to resume office hours. And so I wanted to check with the city manager. My question is, I know historically Los Altos has had strong staff support for office hours. And so I'm curious whether or not the city would be open to maybe structuring our office hours a little bit differently. I know different cities do it differently. One way I know many cities do it is they leave it up to each council member to set the time and day for their office hours, and they just have the city staff post it on the website. And so there's little or no work for city staff. And so I just want to raise that because a resident asked about office hours, and just to get the city manager's feedback on possibly managing our office hours a little bit differently. And an easy example, for example, I could say, you know, I want my office hours to be every Thursday at X restaurant or park every month. And that's what you'll post. And I will manage my own office hours. And Councilmember Weinberg, who I know I can pick on, can say, I want weekly office hours at Grad Park at 10 a.m. And that's what you would post for him. So there's little to no staff work involved.
Thank you, Councilmember Flagger. You still have very strong staff support. It's just there's so few of us now that it's spread out. We had office hours on the list of items we wanted to discuss on how to change with council, and it's actually quite close to in line with what you have suggested, where staff would publicize, reserve either a set area at a city facility or a rotating area. And then let council members manage their own office hours. But we're certainly happy to implement a change or to bring it back to council for a discussion. And thank you for raising it.
Okay. Vice Mayor.
Thank you, Mayor. I'm just going to do a brief update on behalf of the Lehigh Subcommittee, and Councilmember Liang should step in as well if she wants. And just the subcommittee did send a letter last week supporting Supervisor Simitian's latest referral to explore acquisition options for Lehigh. And my understanding is the Board of Supervisors also supported that recommendation unanimously. So we're on a roll, or he's on a roll, or we're all on a roll. So anyway, that's the update. And Councilmember Liang, you can add anything if you want.
Just to remind everyone that there's a meeting with Citian on March 2nd, and that will be discussing Lehigh. So I would encourage everyone to attend.
And we don't have a Brown Act issue as long as we don't all participate and talk to each other. Right, City Attorney? We can all go and listen.
Yes, you can go to other public meetings that have been publicly noticed, as long as you don't discuss subject matter that's within your jurisdiction. Yep.
Okay. Anyone else? And then I'll go. So you all got a copy of the letter that I sent, or I should say not a letter, but I was a part of a press conference that the supervisor had with respect to Lehigh, and then was quoted in a joint press release hosted by the city of Cupertino, speaking clearly only for myself about the Lehigh situation. And then the thank you to the subcommittee for following up on that. That was great. And then I also want to mention that this week we have had not one, but 2 new sculptures installed in town. And this is part of the new, I think there's 12 new sculptures coming. So we're going to have this blossoming in town of new sculptures, and encourage you to go see them and promote them. And congratulations to the staff, who I know are, doing whatever they need to do to make that work, which I know never goes the way it's planned. So I'm told, and to the Arts Commission for all their work on that. And the city manager has comments.
Mayor, I just wanted to close the loop on the office hours and make sure council was okay with staff proposing a change, or did you want us to bring it back?
I think you propose a change and we do it. And then if we want to change what we're doing again, we'll bring it back. But let's not bring it back. Let's just go do something.
Thank you, Mayor. Then the only item I have is to remind everyone, next Tuesday, March 1st, 4 p.m., council will be having their goal setting.
Okay, and I won't be the first person to point out that we have the next housing element meeting the same day. So come here, not there, guys.
But it will be recorded.
It will be recorded. You'll be able to see it, but we have a lot to do next Tuesday. There'll be a lot going on in our city next week.
And that meeting for the goal setting is at 4 p.m., correct?
Yes. Followed by interviews for some commission members. And so unless there's something else, get my hammer here. We are adjourned at 10:50. Yay.
Good night. Thank you.
Good evening. Thank you.